Good afternoon and welcome. This is a special meeting of the Sunshine Ordinance Task Force called for Wednesday, May 18, 2011 at 5 p.m. and beginning at 5:14 p.m. Roll call, please.
Yes, Mr. Chair. Member Snyder? Present. Snyder, present. Member Nee?
Here.
Nee, present. Member Cawthon? Cawthon, present. Member Manny?
Present.
Manny, present. Member Washburn?
Present.
Washburn, present. Member Knebber? Knebber, absent. Member Costa? Costa, absent. Member Wolf? Wolf, absent. Member Chan? Chan, absent. Member Johnson?
Here.
Johnson, present. Member West? West, absent. Mr. Chair, we have a quorum.
Thank you. Could you call the first item, please?
The first item is determination of jurisdiction on a complaint filed by Patrick Monet Shaw against the Ethics Commission for allegedly refusing to release files and memos related to the Laguna Honda Hospital's patient gift fund.
Okay, before we begin this item, is there a representative here from the Ethics Commission? Okay. Had the representative been Mr. Mo or Ms. Eng, I would have had to recuse myself. However, I don't know the gentleman who is here, so I am not going to recuse myself from this item. In which case, please approach Mr. Manette Shaw.
Through the chair, since ethics is not contesting jurisdiction, can we just pass item 1 and move to item 2?
Well, that's our intent. So, if jurisdiction is not contested, is that correct?
Yes, Mr. Chair.
Okay. Is there a motion to accept jurisdiction?
I so move.
Moved and seconded. Discussion. Is there any public comment on the jurisdiction question of this item? Seeing none, public comment is closed. That takes us to the substance of the case. Mr. Manette Shaw, thank you for coming, sir. You have 5 minutes.
All right, thank you, Chairman Nee. First, I'd like to thank the SOTF for its unanimous ruling in my favor on case number 11013 in April. Government Code 6254F, which creates the exemption for investigatory records, which Mr. Mo ignored in his official written response, does not apply to any official or agency whose investigatory files are not, quote, compiled by anyone other than state or local agencies for correctional law enforcement or licensing purposes, end quote. It's clear that the Ethics Commission does not have any correctional law enforcement or licensing functions at all. The courts have limited 6254F to offices and agencies with police investigative power, which the Ethics Commission also does not have. The Ethics Commission is just another agency as far as CIPRA is concerned. As I noted in my March 6th complaint concerning the Alan Grossman versus Ethics Commission case, paragraph C3699-13 of the San Francisco Charter applies only to the ethics laws, not to the public records access laws. And despite the fact that Mr. Threet said that there are few similarities between the two cases, that's patently untrue. Mr. Threet also indicated that if disclosure is permitted by state law or federal law, it should be released. But the issue is not whether it is permitted by state law or federal law, it's whether disclosure is forbidden by state law. Mr. Mo and the Ethics Commission have cited no state or federal statutes that forbids disclosure. In addition, Sunshine paragraph 6724G indicates city agencies' employees may not assert CIPRA section 6255 or any similar provisions as the basis for withholding. Sunshine paragraph 6724H prohibits the use of the, quote, deliberative process, end quote, exemption of CIPRA as an exception for withholding. Sunshine section 6724I prohibits claiming an exemption for withholding based on whether the public interest in withholding outweighs the public interest in disclosure. Invocation of the, quote, interest of justice, end quote, exemption under the official information exemption has been ruled by the California Supreme Court to be the same as the public interest balancing test, which is clearly prohibited by the Sunshine Ordinance, since 67.24I eliminates that test as an exemption. This means Evidence Code 1040 is not an available exemption to any San Francisco respondent. Since SIPRA doesn't exempt ethics investigations, whatever Mr. Moe claims is in the San Francisco Charter is moot and should be ruled irrelevant by this body. Mr. Threet's instructional memo states the central issue is whether the law requires disclosure, but as I said, the fact of the matter is whether state law requires. It is not whether it requires disclosure, but whether it prohibits disclosure. Footnote 2 on page 3 of Mr. Threet's instructional memo quotes Dr. Derek Kerr's complaint for damages filed in Superior Court, but Mr. Threet wrongly lumped a whistleblower complaint about the Laguna Honda Patient Gift Fund, which does not and did not involve charges of ethics violations, together with 2 other of Dr. Kerr's complaints, which did allege conflicts of interest. Mr. Threet should not have lumped the 3 cases together. As you well know, City Charter C3699-13 applies only to campaign finance, lobbying, conflicts of interest, and government ethics cases, and not to whistleblower complaints, nor to whistleblower complaints that do not involve accusations of conflicts of interest.
Thank you. Is there anybody here to present facts and evidence in support of the complainant? Thank you, sir. You have 3 minutes.
Members of the task force, Ray Hartz, Director, San Francisco Open Government, and I know you have had multitudinous discussions about the issue of whether something is releasable or not, and the presumption is that a public record is releasable unless the body that holds the public record can prove justification under one of the exemptions in the law that says they don't have to release it. And from what I got from Mr. Manette Shaw's conversation, they're simply saying he has to prove that he should have it, rather than what we all know is the other way around. The only thing they can withhold are the things that there is a specific justification for withholding. Otherwise, the presumption is that it be released, and he should have any documents that he wants. And the bottom line is, in the Ethics Commission, they have not been much of a support to you in the fact that in the 12 years this body has been going since 1999, passage of the revision to this law, they have not supported you in one of your efforts to enforce sunshine. So basically, they're not your friends. They themselves don't enforce sunshine, and Mr. St. Croix, who is their executive director, finds every reason under the sun to throw these cases out. So really, honestly, in my opinion, the Ethics Commission is not a friend of the Sunshine Law. It is not a friend of the Sunshine Task Force. And since I have no business before them, I'm one of the people who can say, because unfortunately, most people come before these public bodies as supplicants. They come asking you to do something or to keep somebody from doing something to them, and as a result, they have to be very political and not say anything bad about anybody. And then finally, we all know that Dennis Herrera is not a friend to open government. And I have continually raised the issue that the simple fact that Mr. Threet is a city attorney, he is under the total control of Dennis Herrera, his livelihood, his income, his raises, his promotions, his continued working for the city all depends on whether or not he ticks off Dennis Herrera. And we all know that Dennis Herrera does not like this law at all. And he's between a rock and a hard place. I'll give him that. I don't know him personally or professionally, and I think it would be very nice for us to assume that he's going to be an honest broker in these matters. But the bottom line is everything works against that. He is constantly in the position of saying, well, my bread is buttered on this side. I ought to be careful on how I handle it. So you have to look at, with Askins, as Mr. Minetshaw said, his arguments, very often I read them and I say they are somewhat self-serving in the sense that they are doing what the city attorney wants to do in the handling of the Sunshine Ordinance and not what the plain reading of the ordinance requires.
Thank you. Is there anybody else to offer facts and evidence in support of the complainant?
In support, my name is Dr. Derek Kerr. After 20 years at Laguna Honda Hospital, I became a whistleblower, and then I was terminated. We need your help to see if the Ethics Commission is doing its job with whistleblower complaints. Too often, complaints to the Controller's whistleblower program get referred to ethics and buried. For example, our original complaint involving the former health director has been under investigation for 20 months. Tonight, our topic is the complaint we have about Laguna Honda's patient gift fund. It was also referred to ethics, and at that point, the controller abandoned it. This made no sense because our gift fund complaint fell squarely within the jurisdiction of the controller. Also, the Ethics Commission had no jurisdiction over our complaint, and this referral to ethics wasted 6 months and delayed the restitution of $350,000 for another 9 months. Now, it turns out that the controller's whistleblower program can drop an investigation if they get a written notice from ethics telling them to drop it. We requested a copy of that drop the case letter. Both ethics and the controller refused to disclose it. Last month, the Citizens General Obligation Bond Oversight Committee, the body that oversees the controller's whistleblower program, disclosed for the first time that each whistleblower complaint is rated as either high risk, medium risk, or low risk, depending on the risk of loss to the city. We believe that the Ethics Commission and other partner agencies that handle whistleblower complaints engage in risk management for city officials. One way to reduce risk is to bury threatening complaints. Such risk management procedures should not be confidential, and they should not be concealed under the pretense of whistleblower confidentiality. So please support Mr. Minetshaw in his efforts to find out why whistleblower complaints disappear. Thank you very much.
Thank you. Is there anybody else to present facts and evidence in support of the complainant? Thank you. You have 3 minutes.
I'm Doctora Maria Rivero. I worked at Laguna Honda Hospital for 22 years on the Spanish-focused community. Dr. Kerr and I filed the whistleblower complaint against Laguna Honda for misappropriating donations to the Patient Gift Fund, a charitable trust to improve the quality of life for what I would consider to be the poorest of the poor in San Francisco. The Laguna Honda administration was raiding patient donations to have $8,000 barbecues for staff, catered meals for administrators, and gifts for administrators, among other things. Shortly after we filed our complaint, I began to be harassed by hospital administration. 2 months after filing our complaint, I was forced out of Laguna Honda in protest and under pressure. Dr. Kerr was terminated under the guise of a layoff. We are told that our complaint was referred to the Ethics Commission by the whistleblower program, and this is why it took 9 months for the city auditor to complete the audit of the gift fund and to return $350,000 that was inappropriately taken from the patients back to the patients of Laguna Honda. We think that it was unrelenting media and political pressure that forced that audit. And importantly, during this 9-month delay, Controller Ben Rosenfield issued a one-page whitewash review that found no wrongdoing in the gift fund. Laguna Honda administrators had plenty of time to fix and find all of the quote-unquote accounting errors that resulted in patient donations being diverted into staff perquisites. We whistleblowers were driven out of Laguna Honda, and we were widely denounced in press releases as detractors. We are asking this task force to support the release of, number one, documents that explain the 9-month delay in the controller's audit. Did the Ethics Commission indeed tell the controller's office in writing to stop investigating our complaint as required by Proposition C? Also, we'd like to see any document that shows that the Ethics Commission was in fact actively investigating our complaint during those 9 months. We are not asking for any names, details of investigations, or any other confidential information. In the interest of open government, please rule in support of Mr. Monette Shaw. Thank you.
Thank you. Is there anybody else to present facts and evidence in support of the complainant? Seeing none, would the respondent approach, please? Thank you for coming, sir. You have 5 minutes.
Thank you, members. I'm Garrett Chatfield. I'm an investigator with the Ethics Commission representing the department tonight. Mr. Monette Shaw requested investigative files regarding a complaint and any closing memo authored by the Ethics Commission regarding that complaint. Under the charter, the Ethics Commission must conduct its investigations in a confidential manner. The charter says the records of any investigation shall be considered confidential information to the extent permitted by state law. The charter uses the language of records, and that would include all documents both gathered by and generated by the Ethics Commission in the course of the investigation. The charter preempts local ordinances. Thus, it must take precedence over the Sunshine Ordinance regarding the disclosure of public records. The charter specifically outlines that the Ethics Commission must conduct its investigation confidentially. Sections 6276 and 6276.32 of the Public Records Act of California provide the documents that constitute official information are exempt from disclosure as public records. It refers to Evidence Code Section 1040, which defines official information as that acquired in confidence by a public employee in the course of his or her duty, and it was not open or officially disclosed to the public prior to the time the claim of privilege was made. As the provisions in the charter are voted on by the citizens of San Francisco, the voters obviously engaged in a balancing test that the Evidence Code provides by allowing the Ethics Commission to conduct its investigations in a confidential manner. With the exception of task force referrals, complaints received by the Ethics Commission are official information. They're gathered in confidence by members of the public or employees and have not been disclosed to the public prior to our gathering the information. This applies to all of our investigations, not just whistleblower complaints. The disclosure of an investigation record is against the public interest. There's a strong interest in encouraging employees and members of the public to come forward with complaints of violations of law within our jurisdiction. If the Ethics Commission cannot protect either the identity or information provided by complainants, they're less likely to come forward. Disclosure of any information of a record would likely reveal who might have provided the information. And even if disclosure in a specific case would not result in the identity of a complainant or the source of information being disclosed, the disclosure of any investigation record would undermine the entire process. Further complainants might not trust that the information they provide to us would be kept confidential and might refrain from making complaints in the future. Given that the charter must preempt the Sunshine Ordinance and that it allows records of the investigations of the Commission to be kept confidential pursuant to state law, and state law allows that records that constitute official information be withheld, the Ethics Commission cannot disclose the records requested by Mr. Monette Shaw. Thank you.
Thank you. Is there anybody to present facts and evidence in support of the respondent?
Excuse me, I have a point of order. I'm going to have to recuse myself. I've been working, I have a complaint before the Ethics Commission myself, and I've been working with Mr. Chatfield. I thought Mr. Moe would come today, so I'm going to have to recuse myself.
Okay, is there a motion to recuse member Cawthon? Move, is there a second?
Second.
Moved and seconded, discussion. Motion to recuse does not need not require public comment. Roll call, please.
On the motion, Member Snyder?
Aye.
Snyder, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Wolf?
Member Wolf?
Here, yes, present. And
Wolf,
yes.
aye. Member Johnson?
Yes.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 6 ayes.
I believe we have 7 ayes.
Yeah. Usually they call on the requester, and of course I'm voting yes.
Okay. We still have a quorum. We still have 6. With the recusal, we still have 6 members. We can proceed. Is there anybody present to, there was nobody to present facts and evidence in support of the respondent. The matter is back with the task force. Member Wolf.
I didn't hear your name correctly from the Ethics Commission. Chatfield? Yes. Okay, thank you. Yes, please. Just wondering, did you prepare that statement that you
Yes.
read for us today?
Yes, I did.
Okay, great. And are you, all the areas of law that you are citing for confidentiality, you're citing only from the charter? Are you citing any other areas of law?
Well, the charter provision itself says they must be confidential. So we are citing the charter, which allows us,
Are you only citing the charter?
we only cited the charter to Mr. Mountain,
Okay.
yes.
So the Sunshine Ordinance was passed by the voters, and most of it, if not, I would say most of it is mostly dealing with state law under the California Public Records Act. So it's going to be our, I have a few questions under that with regards to confidentiality, with regards to what we're dealing with here, considering that the Sunshine Ordinance does say when there's a conflict between Sunshine and local law, that Sunshine would supersede if it creates greater transparency for the public. So I just want to preface that before I ask my questions. The first question is without asking for any documents, can you verbally confirm that there was a complaint that was?
I cannot.
Why not?
The practice of the commission is to never to confirm or deny that there's an active investigation.
The practice of the office? Under what law is there?
Under the confidentiality of the charter.
The confidentiality is around records, as you said in your testimony, not around the confirmation of whether something has been submitted or not.
Right. I cannot confirm or deny that there's an active investigation.
So you're refusing to answer the question.
I'm answering that. I'm not able to confirm or deny that we have an active investigation.
Okay, I'm not asking for any records. I'm not asking you to produce anything. I'm just asking for if there's a case with the names of these people that has come before you.
I understand what you're asking me. I cannot disclose that to you.
Is it that you don't have the information? Do you don't know the
I
information?
have the information. I am not able to disclose that to you. We have interpreted the charter as to not allow us to confirm or deny whether there is an active investigation.
Okay. All right, that's all the questions I have. I don't think we're going to get any other answers out of this.
Mr. Chatfield,
Shyness.
I have a question. What, in terms of your refusing to disclose the requested records, you cited section in the city charter. What provision in the California Public Records Act or other state law exempts or prohibits the requested records from disclosure?
Well, as I stated in my statement, 627632 specifically exempts official information.
6276.
Point 32.
Point 32? Okay. Now, you stated that the reason for declining to disclose the information is to protect the whistleblowers. Is that correct?
Actually, I did not say that. I said that it protects the identity and source of information for all of our investigations, regardless whether it's an employee of the city or a member of the public, whoever may bring the information forward.
I'm sorry. Could you speak more clearly into the microphone,
Sure.
please?
I did not say that it was specific to whistleblowers. I said that the confidentiality provision protects the identity and source of information of anyone who may bring information to us, whether it be a member of the public or a city employee, regardless of regardless of whether it's a whistleblower complaint or alleging some other action.
Okay, but in this case, it's the whistleblowers themselves who are saying the information should be provided. They obviously are willing to forgo that protection.
Well, actually, the request was made by Mr. Monette Shaw, not the whistleblowers. He was not a
Granted, but
complainant.
the whistleblowers themselves have just testified before us that they want that they back Mr. Monette Shaw, and they're obviously willing to forgo that protection.
Right. I understand that. We're mandated by the charter to keep it confidential. I cannot disclose anything. I cannot stop a complainant from saying whatever they like. I am not allowed, under the confidentiality provisions, to disclose whether somebody came in, who they were, or give them documents that they may have given us.
One final question.
Sure.
Is it not possible to provide the record with any names redacted or deleted?
No.
It's not possible?
I don't believe it's possible to do that.
Why not?
Under the, well, we...
I mean, the technology is there for deletions. Why is it not possible?
Right. We've interpreted the charter as to allow us to conduct this confidentiality, which means we can withhold the records in their entirety. We do not need necessarily to redact it. And quite frankly, I would need to review the records in their entirety to see if what you're asking is possible.
Member Johnson and Member Wolf.
This is not necessarily a question for you, but I would like to just remind the other task force members, and you were not present, but in Mr. Monette Shaw's last case that was regarding the emails back and forth between the city controller and the Ethics Commission, I don't have it in front of me, but there was a September 10th, 2010 memo from the Fair Political Practices Commission, and they post online their investigations of whistleblowers. They actually post whether an investigation is being conducted or not. And the memo is in defense of the attorneys, I can't think of their name right now, but the Attorneys Association that represents that particular interpretation. That memo was in defense of it, and they continue to do it, and that's under the CPRA. So the issue for me about whether or not there's an investigation, I'm going to try to maintain precedent with our last decision, because that's not the charter or the Sunshine Ordinance, that's a state law. And so your interpretation is not consistent with something that the Fair Political, and they actually reveal, the FPPC, who the investigation is about. Now, they don't reveal their investigative files, but they do state whether an investigation is actually occurring. And so that's why last time, in his other case, I felt that this discussion about whether the charter or the Sunshine Ordinance trumps the California, I don't see that you've cited a rule or a law that wouldn't allow them to know whether an investigation, not what was happening, but whether or not an investigation took place. And in fact, I'm not sure how the task force members feel about this, but that may be something that we need to address about the request for the closing memo, because as you know, we heard a lot of things about Stowe Lake, and we really tried to get some information for them, and they had to go to court, and that information was revealed. And there's this closed loop of who is having oversight over whether you're conducting appropriate investigation. There's nobody that isn't connected politically to you guys who oversees that. And in fact, when we talked about, right now Supervisor Campos is the head of the Government Oversight Committee. If he were to report this, if he didn't report it to the media, it would become another closed loop, another closed Ethics Commission investigation that we wouldn't even know if it was being investigated. So that was our reasoning last time. I don't really have a question about it, but I'm just pointing it out to you that the FPPC, they disclose their investigative, whether or not they're having an investigation, and they've defended that and have not been required to remove that information under a state law, not a local law. So for me, that you're going to have to try to come up with the reasoning behind your interpretation not being just a local rule that tries to circumvent the state law. It's not about the actual investigation, but the fact of whether there was one or not. Because I think that the whistleblowers or even the public has a vested interest in knowing whether or not an investigation was conducted. Even if it's the closing memo may or may not have, if you were to disclose it, what the investigation found, but that there was one or there was not one. And so far, that's kind of the information that I can, feel that we have a precedent based on the FPPC's posting of these things that kind of would allow for it. But it's still not the investigative files, but this idea that the disclosure of whether or not there was an investigation needs to be reconsidered, I think, by, based on that, because that's a state law. So that's my reasoning. I just want to explain it to you because you were not at the last meeting.
Thanks.
And that memo is public, and if you want to see it immediately, it's on cityreport.com.
Member Wolf?
Yes. Well, since we're not going to get any confirmation of particular names, can you tell us if there is a pending investigation against Laguna Honda or involving Laguna Honda?
I can't tell you that.
Why not?
For
I'm
the
not
same
asking for
reason.
any names.
For the same reason I just cited.
It's when your testimony was specific about names, naming names, not about what the subject of the investigation might be.
I'm not at liberty to tell you.
Who is at liberty?
No one in the office would be able to tell you because we've interpreted the charter provision of confidentiality not to disclose whether or not we have an active investigation.
Who makes that decision ultimately?
Well, it's under the charter.
Who makes the decision?
The commission.
The commission made the decision.
I feel like you're maybe putting a little bit of words in my mouth. The commission would have oversight of how they're interpreting the rules and regulations and how they're interpreting the charter. I'm not saying that's the directive.
So there's no directive from the commission that this is the way to go about things.
Well,
I'm asking
I
because
understand what
I'm
you're
wondering who you're getting these orders from, who's making these interpretations for you.
well, I mean, I feel as if you might, it's not as if someone's ordering me to do something. The commission as a whole has interpreted that the confidentiality provision requires that we do not disclose whether or not we have an active investigation against a body or a commission or a department or a person. So, I'm not sure what you want from me. I'm telling you what I can tell you, and that's it.
Okay, well, I'm not asking about the complaint at this moment. I'm asking about how you come about making this interpretation. For us, when we deal with interpretations, they're backed up by our legal counsel, and we have legal counsel that is actually a member.
Right.
You have lawyers that are on the commission themselves, and you have legal counsel from the city attorney's office that works for your department.
Correct.
Where is the legal opinion coming from? And
The legal opinion comes from the commission.
so the commission made a formal directive?
At some point. I was not there. I'm not privy to when they did it, or I don't know.
Okay.
So.
Well, that's what I want to know. Okay. Thank you.
Member Snyder?
Mr. Chatfield, I wanted
Yes.
to ask you about the state law, the CPRA provisions that you were talking about,
Sure.
the definition of official information. Is it your position that if something qualifies as official information, it's automatically and necessarily subject to withholding? In other words, it doesn't need to be disclosed if it qualifies as official information under the CPRA?
That's how I've read that, yes.
Because it seems pretty clear to me in the text of the statute, the CPRA, that official information, so I'll go through the definition of official information first. It comes from the California Evidence Code ultimately, but it's information acquired in confidence by a public employee in the course of his or her duty and not open or officially disclosed to the public prior to the time the claim of privilege is made. And you're saying that's what our investigatory files
Correct.
are. You're saying that the Ethics Commission investigatory files fall under that definition.
Right, with the exception of task force referrals.
Okay, so assuming that, just for the sake of argument here, that your files fall under this official information definition, there's a further test that's required that the agency has to undergo further analysis before it decides whether information is going to be withheld as official information. And that analysis is laid out in the next two subsections of the evidence code. That says that a public entity has a privilege to refuse to disclose, in other words, to withhold the information, if the privilege is claimed by the agency and its disclosure is forbidden by federal law. That's not applicable here. Or, and here's the section that I'd like to focus on, disclosure of the information is against the public interest because there is a necessity for preserving the confidentiality of the information that outweighs the necessity of disclosure. So there's an analysis that needs to go on here before the Ethics Commission decides to withhold the information as official information.
Correct.
Did the Ethics Commission undergo that analysis in the case here, in the case before us?
Yeah, as I've stated, well, in all of our cases, we feel that the interest of the public is served by withholding or keeping the information confidential so as that we can encourage other people to come forward and provide us with information knowing that that will be done in confidence.
So this is a blanket determination that the Ethics Commission's made as to all investigatory files, again, with the exception of the task force files. What I'm asking is, do you ever apply a specific individual analysis case by case?
Yes, and in this case, I can tell you that that was done.
That analysis was done in this case?
Correct.
And so can you tell me what, in this case, given that some of the information, much of the important information about this investigation is already public, can you walk me through the balancing test that the Ethics Commission went through here?
Well, first of all, when we received it, that's when we did that test. I mean, that's when we looked at that information, not now that it's all been disclosed. So I understand what you're saying. However, I can't confirm that there is an investigation, you understand that. But any investigation must remain confidential until it's either dismissed or there's a hearing on the merits, at which point certain things will be made public because it's introduced.
I mean, see, what you just said implies to me that there is no individual analysis that goes on. You're saying any investigation must remain confidential, that you don't apply this balancing test on a case-by-case basis. You just sort of have decided that the information is not going to be public. You're saying that
you asked me two different. You asked me one if we do it blanketly and one if we do it on this case. And generally, our investigations, we presume the public interest or disclosure is in the public interest, given that we want to preserve the comfort, if you will, that someone can come forward. And if in this case, which I cannot confirm that there is one, I mean, you're putting me in a difficult position because I'm not at liberty to say whether or not there is or isn't a case. I understand that, the complainants can state that there may be.
Has there ever been a case where the Ethics Commission found, after conducting this balancing test, that there should be information released?
I don't have that information for you.
Do you know of any?
I don't have that. I don't know offhand. No.
Member Wolf?
Yes, Mr. Chatsfield. Under the California Public Records Act 6253.8, well, let me first ask this question. Do you consider the Ethics Commission to be a law enforcement body?
No.
Okay. So under Section 6253.8, 6253.9, F, it speaks of records of complaints to or investigations conducted by and intelligence information, so on and so forth, by the Attorney General, Department of Justice, California Emergency Management Agency, or any state or local police agency, or any investigatory or security files compiled by any other state or local police agency, or any other local agency for correctional, law enforcement or licensing purposes. This specifically speaks to penal code. Okay, so that's as far down as it goes with regards to withholding information by an agency that carries out investigations. However, it says in this section, state and local law enforcement agencies shall disclose the names and addresses of persons involved in or witnesses other than confidential informants to the incident, the description of any property involved, and it goes through a whole list of things, things to the victims of an incident or an authorized representative thereof, an insurance carrier against which the claim might made or may not be made, any person suffering bodily injury, and it goes on to a whole list of who else. Under that, there is a requirement for law enforcement agencies to produce this information if a complaint or an investigation is carried out. It does not include anybody that is subordinate or under a sub-level under that. So if the requirement under state law is that police, law enforcement agencies, which actually have a higher level of confidentiality and dealing with these kinds of investigations, are required by state law, then there's no provision that would cover for you. The state law would supersede the charter. So you must produce at least whether there's a complaint that has been filed, at least.
Well, I would just comment, if I may, that
Yeah,
you
of
just
course.
cited a provision that we're not relying on and as you stated, isn't applicable to our agency, so I'm really not sure.
The California Public Records Act is applicable, and these are the only restrictions they make on local agencies. Anything that is not contained in this particular way in this section must disclose. That's what it's saying.
Okay.
You're not covered under that umbrella. And the fact is, they're saying that even a local law enforcement agency cannot withhold. That's what I just read, is saying that they cannot withhold the information. It actually says names and addresses of the persons involved.
Okay.
At this time, the respondent and then the complainant will each get 3 minutes to make any concluding or rebutting remarks. Mr. Chatfield?
I have nothing further to add apart from what I've already said.
Thank you. Mr. Manette Shaw?
I have never been to such a kangaroo court proceeding in my life. Kafka would be proud of this. For one thing, even though Mr. Moe's written letter did not cite 1040 or the balancing test or anything else, Mr. Chatfield here tonight is asserting that. Ethics did not acquire that whistleblower complaint in confidence prior to the time that it was made public. And they did not assert it prior to the time that the whistleblower complaint was quite widely shared by Dr. Kerr and Dr. Rivero quite publicly. So they can't assert 1040 since it was already out there in the public domain. The charter cannot trump CIPRA. In Mr. Moe's March 23rd letter, he tried to pass off that Ethics Commission regulation for investigations and enforcement proceedings, section 13B1, trumped CIPRA. It's appalling. The Ethics Commission's regulations do not take precedence over CIPRA. You should read the Controller's Whistleblower Policy and Procedure Manual that we just obtained under a public records request. The Controller's P&P outlines a variety of communications that should occur with the complainants who file whistleblower complaints. And I urge this body to get a hold of that document, or I'll just email it to Mr. Rostam, and then he can forward it to you. You should read what the controller is attempting to do to keep all this stuff totally secret and to twist the intent of a whistleblower program into a risk management program to save the hides of senior city officials and elected officials, and in cases where the amount of quote-unquote loss to the city is in excess of $50,000. That policy and procedure manual will blow your hair away. I would specifically like you to consider, before issuing your wording for the order of determination, that you consider a violation of 67.24G. I'm hoping you guys will jot this down. 67.24 I, 67.27B, 67.24C7, and order in your order of determination that ethics must release both the closing memo and its complete investigative file, whether or not they have to redact the whole thing and give me a single sheet of paper with nothing but black redactation on it. Because if they do that, I'll be back. Thank you.
Thank you. Matter is back with the task force. Member Snyder?
I think the appropriate analysis here, in my opinion, is to go to the California Public Records Act. I know there's a lot of, we could debate forever whether the charter trumps the Sunshine Ordinance trumps the charter, but I think there's no question that the Ethics Commission is subject to state public records law. And I think under the California Public Records Act, they are entitled to withhold official information in quotation marks. I think that's beyond question. However, before they do that, they have to undertake a balancing test, which it's apparent to me they haven't done. And they've done it in a sort of blanket fashion, and they sort of insist before the fact that everything that they investigate is subject to withholding under this official information exemption. And that, it's apparent to me, wasn't applied here. There was no balancing test applied. They haven't asked whether it's in the public interest to disclose or whether it's in the public interest to withhold. They need to do that. And because they haven't done that, they don't have a basis under the California Public Records Act to withhold this information. It should therefore be disclosed. I think our analysis and our order of determination can be very simple. I think it's a violation of Section 6253 of the California Public Records Act that they haven't disclosed the information requested. I'm not personally sure whether we can, at this point, given what we know, go so far as to say they have to release everything. At the very least, they need to release information and redact some of it, in my opinion. So I would move to find a violation of California Public Records Act Section 6253 et sec, in other words, and following. And I would leave it at that, but that's my opinion.
Is there a second?
Second.
Moved and seconded. Discussion. Member Johnson?
Just a friendly amendment, I would also wonder if you would be interested in, based on your reasoning, that they would find the violation of 6726 withholding kept to a minimum, because under the Sunshine Ordinance, they could redact if they don't have, you're saying they didn't give a proper justification.
Yeah, I think there's I'm about 95% sure there's a provision in the California Public Records Act, a similar provision to withholding. I can't find it right now. The reason I would resist bringing the Sunshine Ordinance in is because then we get into this debate about whether the Sunshine Ordinance, whether they are permitted to withhold, kind of despite the Sunshine Ordinance. Does the Sunshine Ordinance necessarily apply to them? It may not. I think we are on much firmer ground in saying that the California Public Records Act applies to the San Francisco Ethics Commission, and they haven't disclosed information they should have under state law.
So if there is one, if Bruce can find this section, you'd add it if it was under...
Certainly. Or we could, yeah, I would agree to that. I think bringing in the Sunshine Ordinance at this point kind of unnecessarily complicates things, in my view, but I'm open to persuasion on that.
Is there any public comment on this item?
Good evening, Task Force members. Thomas Piccirillo. First, let me thank you, the 7 of you, for showing up tonight in the special meeting. I know you're here because you have a backlog of cases, and I appreciate, and I'm sure the complainants behind me also appreciate you being here. Let me say this, though. Clearly, Mr. Shaw's rights have been violated. We're under either the Public Records Act or the Sunshine Ordinance. My concern, though, is that The chair has previously recused himself, and I think the reasons that he recused himself the last time were broader than knowing the respondents who testified. If that's the case, then I think recusal is proper now. I understand that there won't be a quorum for Mr. Shaw, but if I am correct in the reasons that the chair gave that are broader than knowing the respondents who testified at the last hearing, you will give Mr. St. Croix another reason to deny the order of determination. Thank you.
Thank you. Is there further public comment on this item? Seeing none, public comment is closed. No, sir. This is still on the matter of the complaint. Public comment is closed. Further discussion. Roll call, please.
On the motion, Member Snyder?
Did you find?
I didn't find
Can
it.
I,
Because
can I ask?
without adding,
Member Johnson.
if you don't add the 62, because of their analysis of the reasoning behind not disclosing anything, I think it's difficult to, we may say that some of the files are open to, but we haven't said anything in specific, like the investigative files versus the closing memo. I personally, specifically for the reasons that I stated, that the FPPC posts whether there's an investigation being done, and they've defended it under what Member Snyder has stated. But I would somehow like to put something in there about withholding kept to a minimum, because that's kind of a real key to redaction, to the reasoning behind why we're talking about redacting names, we're talking about redacting investigation portions, we're talking about redacting, and not that you can disclose if there was an investigation, which in essence, a closing memo would also be just disclosing that exact same thing. There was an investigation, even if they decided they would redact what the outcome was. So I would go, I'm still supportive of the motion, but I just feel like it would be more directive if we could put in some kind of a withholding or a redaction portion.
Excuse me, Mr. Minute-Shaw, could you be seated, please?
Well, I'm just afraid they won't support it. I'm trying to find a way for it to have some, support. I understand that. I like that you have this a solid, cohesive line of reasoning. 6253 says that they have to disclose, or don't have to disclose official, but the official information has to be balanced, right?
Well, it's actually, the official information stuff is in 6276. The reason I say that's the provision that allows them to withhold certain information. 6253, which is what I'm proposing, is just the general provision that says agencies shall disclose records. That's what they've violated by not disclosing appropriately.
And if I could make a second motion so that yours could be standalone if it wants to.
Sure.
If you wanted to avoid the combining them.
Well, I mean, do you want to add just some wording saying to the extent that records may be released with redactions, the Ethics Commission shall so release the record, something to that effect? Is that what you're saying?
That would be in the order of determination.
Right.
But I personally think that if I don't believe that there's been a precedent set one way or the other of whether the charter or the Sunshine Ordinance trumps one or the other. It's all been opinion. And there's been no recognized ruling authority that has ruled on that. I discussed this with Alan Grossman the other day when we were discussing the Ethics Commission regulations. So my preference, though maybe I'm wrong, but my preference is to hold them accountable under San Francisco's local laws, that because the Sunshine Ordinance enhances the Public Records Act, and there's a provision, it may be the one that we're citing, that enhances public access under the CPRA. I just think that if we're going to say that they have to disclose certain things, And though they're disclosable, then under the Sunshine Ordinance, their withholding has to be kept to a minimum. But I understand if it's not something that you want to.
Please be seated, sir. Please be seated, sir.
Because, for example, 6724C7 that Mr. Minette Shaw had cited, it states that if they had confirmed during their investigation the misuse of public funds by an, I forget what it says, elected official, that's required under the Sunshine Ordinance to be disclosed. But if they won't even disclose if there was an investigation, then we would never know if they were not disclosing that particular, if they confirmed it or not, we would never know. But that is required under the Sunshine Ordinance. And since they would be the ones that would always conduct that investigation, that's a huge conflict between the ordinance and the charter, that all, to interpret that all things are confidential and not disclosable, but to have that provision in the Sunshine Ordinance saying, but if they do this, you must disclose it. That they handle those complaints.
Member Wolf?
Just to answer Member Johnson's question with regards to the CPRA and this particular issue, the only thing I can find is regarding law enforcement. Every agency must reveal. They're all public records. Investigatory or not, it's only based upon penal law, not based upon any other law. And so I agree with Member Snyder that that this order be based upon CPRA because that will cover all. I also agree. I understand what you're saying about including the Sunshine Ordinance part of it, but I think that will create more controversy and more angles for one or the other parties to make to try and continue to make a case. I think if we keep with the overarching law that supersedes all local law, I think we play it very safe, and the Sunshine Ordinance and the CPRA actually extends the hand to local government to expand on it automatically. So I think we should stick with what we have.
Member Snyder?
Mr. Minette Shaw, can I ask you a question? In your complaint, you obviously centered your complaint on the Sunshine Ordinance. Can you give me an explanation of why you didn't anchor it to the California Public Records Act?
I did. If you read...
Well, I see it's there also.
To answer, with all due respect, if I could have my 5-second answer or whatever.
Please.
I based writing the first complaint, 30 pages, and the second complaint, whatever it was, 9 or 10, addressed it to a local body known as the Local Sunshine Task Force. And I cited many of the Sunshine Task Force sections, but I kept backing it up with references to CIPRA, because even the Sunshine Ordinance says that any exemption to CIPRA has to be given to the complainant when they're turned down. So I would really strongly request that you split this into 2 motions, and as Member Johnson recommended, put something in there about the Sunshine Task Force, because that's what you are. That's what I wrote the complaint about. CIPRA is mentioned several times in the ordinance, and I don't see any harm in having 2 motions and something in the order of determination that cites both CIPRA and the Sunshine Ordinance that both of them were violated. Does that answer your question?
Yes, thank you.
Thank you, Mr.
Yeah.
Thank you.
If I were to make a motion, would it be before or after you vote?
Well, it depends on whether you want to amend the current motion.
Member Snyder does not wish to amend, and I understand.
Okay. In that case, let's take the roll call on the current motion, please. With
On the motion to find a violation of CPRA 6253, Member Snyder?
Yes?
Snyder, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Wolf?
Aye.
Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 6 ayes.
Okay, just one minor correction. The motion was to find violation of California Public Records Act, Section 6253 et sec. Member Johnson, did you want to bring
I
forth
would like
another
to make
motion?
a motion because we're saying that they had a failure to justify withholding under the CPR, which is required under 6727 of the Sunshine Ordinance, that they are in violation of 6726 because they did not keep withholding to a minimum
Of the Sunshine Ordinance.
of the Sunshine Ordinance.
Is there a second?
I second.
Moved and seconded. Member Snyder.
So it's in my opinion, the Ethics Commission so I can't support the motion because in my opinion, the Sunshine Ordinance by itself permits the Ethics Commission. Let me rewind. So the Ethics Commission under the Sunshine Ordinance can withhold information, which I think this information likely this information likely falls under this umbrella to the extent permitted by state law, and it's state law as incorporated by the Sunshine Ordinance, which I think is being violated here. I think so. I'm not comfortable finding a violation of the Sunshine Ordinance because I don't think it applies here.
If the Sunshine Ordinance doesn't allow them to do certain things unless it's required by state law, that's a violation of the Sunshine Ordinance. I can't take in how it could be otherwise. If the Sunshine Ordinance says unless you can cite the state law, you have to keep withholding to a minimum, then you got to keep withholding to a minimum unless you've cited a state law. That's a violation of the Sunshine Ordinance. I just don't understand how, if they're not giving you the section of the state law, that's not a violation of the Sunshine Ordinance. Yeah. And there's kind of a conflict in their interpretation of everything, and it's clear throughout in 6724C7, where it says that if a public official has to, if a public official has, if it's confirmed that they misused public funds, which is what they're saying about the gift fund, it must be disclosed. But if we don't even know that how would we ever enforce that? If their interpretation of the Sunshine Ordinance is that it allows everything to stay confidential, including whether there was even an investigation. That to me signifies their interpretation has not taken into account the entire totality of the Sunshine Ordinance because it clearly violates 6727 C7. 6724C7 that requires that particular information to be disclosed.
Member Wolf and then Member Snyder.
I think, I am leaning to agree with Member Johnson on this. In Section 6727 on the justification of withholding, there has to be a specific permissive exemption under CPRA. There has to be some specific statutory authority in CPRA. And there would have to be, where it just says, most of which is exempt from disclosure under CPRA and this article, that the custodian shall inform the requester of the nature and the extent of the non-exemptive information, so on and so on. And their discussion is not based on open records law at all. It's based only on the law that they're making their argument only based on the law that governs them and them alone. So I find it a little hard because 6726 it basically says you got to do this, and 6727 is just the justification for whatever they're supposed to do. So it's not inclusive.
Member Snyder.
So, yeah, I got confused and misspoke, and I think I've unnecessarily muddied the waters. I'm not. So what I intended to say was that the charter, not the Sunshine Ordinance, but the charter provides that an Ethics Commission investigations shall be confidential, except to the extent permitted by state law. And so if we're going to find that they violated the, and that provision of the charter, in my opinion, overrides the Sunshine. That's where you get into this trumping debate about whether the charter trumps the Sunshine Ordinance, and we can go on and on about that. But my point is that, in my opinion, at least in this instance, the charter kind of supersedes. And so the charter says the Ethics Commission has the power, in fact, it must make their investigations confidential. It doesn't matter what the Sunshine Ordinance says, in my opinion. I know there are people that believe the Sunshine Ordinance overrides the charter or trumps the charter, however you want to say it. I don't necessarily agree with that, and I think it's messy to bring in the Sunshine Ordinance because the city charter says the Ethics Commission has to keep things confidential.
Just a response on that.
Member Johnston, then Member Wolf.
I strongly disagree with you and cannot. I would request to rescind my vote if the reasoning is that the charter trumps the Sunshine Ordinance, because I strongly disagree with it. That means that any city could create a charter that trumps whatever state law they want it to trump.
No, the state open records law still applies. State open records law the CPRA always trumps the charter.
So you're saying they could, could not do that. They could not trump.
That's why we're going to that's why my reasoning is based on the idea that state law supersedes. That the city charter can't render something secret that the State Public Records Act says is not secret. That's an impossibility.
I still agree with what Member Wolf was saying, but I understand if the precedent we would be setting would be that the charter always overrides the Sunshine Ordinance, and I would keep in mind that Supervisor Wiener at Thursday's Rules Committee is about to present a requested charter amendment that would allow them the Board of Supervisors to change voter-approved ordinances and resolutions after 3 years. The Board of Supervisors could change it. So I strongly urge the members to hold our city officials accountable to our own sunshine law, because they're coming and they're going to try to change voter-approved ordinances, and that includes ours.
Member Wolf.
Members, I would strongly urge you to resist a creation of a new precedent. I don't agree with Member Snyder's interpretation of this. That is a new precedent, and we don't agree with it. I'm serious. To say that there's any conflict between the Sunshine Ordinance, whether it trumps the charter or not.
That's not what our order says. All we're saying is they violated the California Public Records Act.
I understand that, but
we're not weighing in on a violation of the Sunshine Ordinance.
We're saying, but now we're on a new motion. We're on a new motion to say that they violated the Sunshine Ordinance under 6726, right? So under 6726, it doesn't speak to anything but the California Records Act. That's all it speaks to. So if you look at it, think of it as a flow chart. Okay, California Public Records Act trumps the city charter. If the Sunshine Ordinance, if there's question that the Sunshine Ordinance is in parallel or a peer to the or even subordinate to the charter, this provision says, go back to the California Public Records Act. It doesn't even, it just repeats what the California Public Records Act says.
So I think that our order, that the withholding was in violation of the 6253 California Public Records Act incorporates that.
But this expands as allowed by the Public Records Act to provide more, make it more ambulatory. Okay, where the California Public Records Act doesn't provide, it doesn't speak to it. It says if a local law is created and they want to expand things, make it do other things, as long as it doesn't exceed what we've already done, and it makes things more more sunshine, more transparent, more disclosable, then go for it. So I don't see there's any problem in this. I don't see that there would be any discussion, any argument that citing a violation of 6726 supersedes anything. It just repeats California Public Records Act. That's it. I don't see there being a problem here.
Is there any public comment on the motion to find violation of 67.26? Seeing none, public comment is closed. Before we take roll call, the chair will just issue this reminder that at the task force's regular meeting of April 26th, the task force voted to invoke a procedural rule that on substantive matters, a simple majority of those present, as long as we have a quorum, a simple majority of the members present passes a motion. There are 7 members present today, 1 recused. That means a simple majority of 4 or more passes this motion. Roll call, please.
Yes, Mr. Chair. On the motion, Member Snyder?
No.
Snyder, no. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Wolf?
Aye.
Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
No.
Nee, no. Mr. Chair, we have
We
4
have four
noes
ayes.
and 2 ayes.
No.
We have 4 ayes and 2 noes. The motion passes. At this time, we're going to ask for general public comment on items not appearing on today's agenda. Is there any general public comment? Speakers have 3 minutes each.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. 40 years ago this month, I stood in an armed forces entrance and examining station in Coral Gable, Florida. I raised my hand and I took an oath where I swore to protect and defend the Constitution of the United States against all enemies, foreign and domestic. I swore to bear true faith and allegiance to the same. There were some other things in there about obeying orders and the Uniform Code of Military Justice, but it ended with, "I so help me God." And following that, I spent a couple of days thinking about what I had just done, committing myself to the United States Navy, giving up my rights to do a lot of things that most of us consider. But I also considered the fact that when I took that oath at the age of 21 years of age, it is the first time I ever had to promise to do anything to pay back the country that I live in and the flag that I serve under for the rights that I had been given under the Constitution. And I thought that was marvelous. I thought, I got these, I didn't have to do anything with them, and I've gone 21 years and had all the protections with really none of the obligations to do anything to support it. So when I got out of the military, I thought to myself, I can't in any good faith put that oath down. I can't just say, well, now I'm out of the military, I did my job and it's all over. And that's why I've spent the last 4 years coming before the Sunshine Task Force, going to the Rent Board, the Police Commission, the Public Utilities Commission, and all these different hearings, which are, they're dumber than dirt and boring and full of technical stuff you don't understand and minutia. But the things I was looking for was the fact that, number one, citizens of this city should not have to go before any city board, body, commission and fight for the right to speak. And yet they do. This body found the police commission in violation when they found me to have been cut off, and I watched them still, after that determination, continue to do it to other people. They then manipulate their agenda, where they come in and they go to item number 5, which is moving into closed session. They go into closed session and tell everybody in the public that they have to leave. And they don't tell anybody when they're going to actually get a chance to speak or if they're going to get a chance to speak. And the very first time they did it when I was there, they didn't go back into open session for 3 hours. And I was the only person left. And even then, that was when they tried to stop me from saying anything about it, saying, you can talk about the substance of the matter, but you can't talk about our procedures or our policies. And I go, no. Under all levels of law, the federal Constitution, the state Constitution, Brown Act, the CIPRA Act, whatever you want to cite, or California Public Records Act, anything you want to cite, I and any other citizen have the right to get up here and shouldn't have to fight anybody to get those. And they say, well, we're just enforcing our procedure. I hate to break it to them, but no city body, no city official has the right to get up and violate the Constitution and tell people there are things you can't talk about.
Thank you. Further public comment? General public comment? Seeing none, general public comment is, oh, I'm sorry.
Chairman Nee and Commissioners, thank you. My name is Deborah Benedict, and I obviously am here because I have something before you this evening, but I'm a little troubled because having gone to one of the two outlets that allows for public meetings to be noticed, I came up with 4 pages of organizations under nonprofit noticing that sometimes gave 1 day, sometimes gave 10 days. And I'm uncertain as to whether there is any oversight as to when a notice comes in about when the meeting and when it comes in is. So I'm confused and I guess a little curious about whether it's important or necessary to file a request on each one of these for not adhering to the 30 days notice. And there's so many of them that I guess I'm just curious as to whether there is anyone looking at them ever, anywhere, or if it's just a matter of waiting for the wheel to squeak. So thank you very much.
Thank you. Is there further general public comment? Seeing none, general public comment is closed. I think Ms. Benedict's comment is worth a response. There are certain requirements that openness requirements that nonprofits fall under Section 12L of the City Administrative Code, and if there are that many violations, you have to decide which of those are really worth pursuing. I don't know what kind of time and resources you have. If you wanted to go after all of them, it would be totally up to you. I think if you did something like that, you would have to file each complaint individually. Because we're not going to, I don't think it would be appropriate for this task force to take a whole slew of respondents under the same complaint. That's my initial reading anyway. But Ms. Benedict, you would have to decide really how important it is to you to bring attention to these matters. And you obviously, if your energy and your time and your resources are limited, then you have to kind of pick and choose which fights you really want to wage. That's the best advice I can give you on the matter. Your comment is certainly appreciated. Mr. Clerk, could you call the next item, please?
Attorney, just a second.
Excuse me, Member Cawthon?
Could I just want to say
and
something?
Member Washburn.
I have to leave. I have a group that I'm on the board of is having its annual dinner tonight, and I do apologize. If we hadn't had a quorum, I would have stayed.
Member Washburn, Member Wolf.
I have a question regarding the matter that Ms. Benedict raised. Is there a body in city government that apprises nonprofits of their obligation to properly notice their meetings? They have to have 2 public meetings a year and so forth.
Well, I'm not sure if the city attorney would do that or the agency with which the nonprofit deals, through which the nonprofit deals with the city. However, if there is an openness violation, then it would come to the task force, and the task force would then either, if it's a public records violation, task force would send it to compliance and amendments. If it's an open meetings violation, it would have to go to, I would believe it would best go to education, outreach, and training.
Right, I understand that if there's a violation that somebody finds out about, but I'm just wondering, part of what we've done historically is educate city government, educate the public about the open government laws, and I'm just wondering I mean, city employees have to take sunshine training. I'm just wondering, is there some mechanism for educating nonprofits about noticing meetings and having public meetings? And if, you know, if there isn't, shouldn't there be such a mechanism? That would be, would be something that we could put into place or make sure that's there and oversee it.
Okay, I think we could probably discuss that at a later date, perhaps. We have a lot of items on our agenda.
I know. I'm just wanting to
prefer to proceed.
Want us to make a note of it because it's important. Maybe
Wolf.
Chris, if you could make, or through the chair.
Member Wolf?
I just wanted to mention that, you know, with Member Cawthon's departure, I equally paid for the same event that she's going to, and called and told him I wasn't going to show because of this meeting. I just wanted to say that. I think I'm a little disturbed by that.
Well, I think there is reason for concern, and before we adjourn tonight, we are going to take up the matter of member absences at tonight's meeting, determine which ones we want to excuse, which ones we don't. Mr. Clerk, could you call the next item, please?
Item number 3 is determination of jurisdiction on complaint filed by Larry Littlejohn against the Sheriff's Department for allegedly denying access to jail census.
Is there a motion to find jurisdiction?
So move.
Moved and seconded. Has jurisdiction been contested?
No, Mr. Chair.
Okay.
It hasn't.
Is there any public comment on the jurisdiction question of this item? Seeing none, roll call, please.
On jurisdiction, Member Snyder?
Yes.
Snyder, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Wolf?
Aye.
Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 6 ayes. The motion passes.
Okay, that takes us to substance. Mr. Littlejohn, please approach the microphone. Thank you for coming, sir. You have 5 minutes.
You may remember me. I was at your April 28th meeting. I sat in the front row. I was here for 7 hours. I read that letter you had from that other lady. And when I left her, I was a little bit put out. I mean, I'm 75 years old, and 7 hours sitting here was a little hard. And I thought, I had commitments with my time there. Then I stopped and I thought about it. And I thought that you guys coming here, and you're down here, I said, what you go through, you know. I really appreciate it because I think the Sunshine Ordinance is important. I had commitments for my time today. Because when I came up for Friday, I didn't know the meeting was going to be today. I thought it'd be down, you know, it's a special meeting. So I've had commitments for my time. So I want to address a procedural question here, and then I want to address the substance of my complaint. First question I want to ask, do you take testimony under oath?
No, sir.
No?
No, sir.
Okay, because I'm willing to go under oath. Here's a procedural question. I'm reading the letter from the assistant counsel for the sheriff, and I think that is just outrageous. Now, I got the notice of the meeting, and I read the 67, and it says,
Speak into the microphone, please.
excuse me, it says, an authorized representative for the custodian of the public records requested shall attend any hearing and explain the basis for its decision to withhold the records if requested. Now, you had analysis by Mr. Tree at the last meeting, which the Assistant Legal Counsel of the Sheriff's Office was furnished with, that raised some questions that needed to be addressed. Okay. Now, I'm a former sergeant in the Sheriff's Department, and I happened to just recently look at the payroll records for the Sheriff's Department. Let me tell you this. Almost all the sergeants in the Sheriff's Department that have worked there make over $100,000. Every employee of the Sheriff's Department except the sheriff gets overtime pay. I happened to look up Mrs. Horn's salary. I wish I brought it with me, but I'm pretty sure it is in excess of $120,000 a year, plus overtime. Now, I think, I personally take it, and I think you take it for the fact that she says in her letter, finally, I will not be able to attend the next meeting scheduled for, as I have a previous commitment scheduled at that time. I wish somebody would ask her what the previous commitment is. What could be more important than attending a meeting that you're required to by the charter? But I'll also point out to you that in the sheriff's department, it's 24-hour place. You know, there is more. There is a council. There is this, and there are a lot of other people in the sheriff's department that are making good money. 8550 Bryant Street, there are a lot of administrative people that could be here. Some other person other than she could have been here at the representative that's here. She could have briefed them on what the issues are. It's not that difficult. There's public affairs with all kinds of people in the sheriff's department that could have been here today. If she had some previous commitment that was so important that she couldn't be here, the sheriff could have sent somebody else here. I'm here. You're here. I think it is really outrageous that the sheriff does not provide somebody there. This is not a department that has very few employees and they're not around. There's a lot of sheriff's department employees, right? There are probably some sheriff's department employees in the sheriff's office right now. So I really resent that. I think you should take some note of that. Okay. Now, if you need to contact me regarding this information, I can be reached out. Did you ever contact her, Ms. Ransom? Have you contacted her?
Excuse me?
He's asking, I think, if we have his contact information. Is that correct?
Pardon? Did anybody contact her? Okay. In the analysis.
Excuse me, Mr. Rustin? Do you know if the contact was attempted?
Yes, Mr. Chair. I sent out the notice, and her response was here.
Oh, okay. We do have a response then. That's correct. I'm sorry. Proceed, Mr. Littlejohn.
I didn't hear the answer.
We do have a response from the sheriff's office. Have you seen a copy of this note?
Are we talking about the May 17th letter?
This would be, yes, the May 17th memo.
Is that it?
Have you have seen it?
Yeah, okay.
Okay. Thank you. Continue, please.
What she says is, if you need to contact me regarding this information, I can be reached at this phone number. In the analysis that your attorney, Mr. Street, made, he raised a lot of questions that she could have responded to in writing, such as, is there existence, as she says in her letter, that there is no, I'll back up, I'll get to the subject thing, but the procedural thing is, they're not here. You're here. I'm here. They're not here. The sheriff's department has a lot of employees on duty right now. They get paid very well. And I really think you should inquire as to why the sheriff didn't send a representative here as required by the city ordinance. That's really important. Okay. Now, the substantive issues here are this. As I said in my letter to you, I think that she misrepresented my complaint. I think Mr. Street misrepresented my complaint. Here is the issue. Like I said, I worked for 10 years for the sheriff's department. You used to go into the sheriff's department, maybe none of you had this experience, and you want to leave some money for somebody. So you go to the money property window, and facing right on the wall is something called the jail census. I'll tell you what the jail census is. The jail census is a computer-generated form. It's generated, I think, 3 or 4 times a day. It lists every person that is in the county jail held by the sheriff by name, age, name, date of birth, charge, race.
Mr. Littlejohn, your 5 minutes has expired. Sir, could you please wrap up your remarks?
Pardon?
Your 5 minutes has expired. Could you please wrap up your remarks?
Okay. I'm sorry. The point is this. I was denied that list take off the wall. I was not doing that. And I've been denied that list repeatedly. And she says in her letter that she has no record. Let me make this point. That's why I asked you to take it on.
Okay.
April.
Thank you, Mr. Littlejohn. Please be seated. Is there anybody to present facts and evidence in support of the complainant? Seeing none, is the respondent present? Is there anybody to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force. Does anybody have any questions for Mr. Littlejohn? Member Washburn, Member Wolf.
Mr. Littlejohn. Sir?
Yes.
Could you, first, yes. I want to make sure that I understand the nature of your complaint. So you say in your letter to Chair Nee of May 13th, last week, you said that this complaint is not about the jail census for August 9th, 2005. That was just one instance that
Yes.
you've asked for a copy of the jail sentence repeatedly since then.
Yes.
And actually in April and May of this year.
Repeated before that with witnesses.
So when you ask someone for the jail census, what are you told?
They tell me there was a policy of the Sheriff's Department that they do not make the jail census public. Now, Assistant Legal Counsel is telling you there is no such policy. Well, I'll tell you, there is a policy. I've been repeatedly told there's a policy. You can go down there yourself. You will not get the information. And you'll be really misled by that. There is a policy of the Sheriff's Department that they will not let people look at the jail census. And when I went to the city attorney sent the sheriff a letter saying it's a public record, you have to make it available. The city attorney told me that in 2005, 6 years ago, and they do not make it available. Can you think of anything more fundamental in a democracy that we have, that you can go down there and look and see who's in jail, and they won't let you see it? Now, let me say a couple of practical reasons. First time this happened to me, a friend of mine said, "Will you put $20 on the books for my boyfriend, Nate?" Okay, yeah, I'll go down there and do it. Well, I got down there, I realized I couldn't recall his last name, right? Well, I knew Nate was a 25-year-old white male in charge for drug charges in San Bruno in that jail. So I just, it's not on the wall. So, well, can I just look at, I'll go down and listen, see all the people whose first name is Nate, or 25 years in drug charge, and then I'll put, because you have to have the last name of the person. No, you can't do it. Repeatedly, people have good reasons to want to see. A lot of times when somebody's arrested, they're arrested under a name different than their people know them. You know, I know somebody, it's James Brown, right? And he's in jail. Well, I go down there, there's no James Brown in jail. Because the name he's arrested under is maybe his true name or a phony name. It's James Allen. But I know his age, I know the day he was arrested, I know his arrest necessity, and what the charges are. I'll find out what it is, People can be put in jail and nobody can find them. Now, here's what happens when you go to jail. You get arrested, you go to jail, you get 2 phone calls, right? And if the people you're calling don't answer, too bad. Now, after that, in order to use the telephone, you used to go there, you had money, you have no money. You can't collect calls, and you can't get to the telephone even. And so what happens, you're isolated from everybody you know. You have to have people. The sheriff for years used to allow people just arrested to have visitors for 3 days after they were arrested. That means friends can come out and get in touch with them. Nowadays, that's not true. You cannot get in touch with somebody who's in jail unless you visit them. And it takes about 3 days for them to be visiting on Saturday and Sunday morning. A lot of people go to jail, and there's nobody they can contact to take care of their personal affairs, like their animals, their rent, and things like that. People go to jail, are ripped off all the time in hotel rooms. People know they're in jail, go in the hotel room and rip them off. That is really a serious thing for people. People don't even find out somebody's in jail. That's outrageous. I think it's a really important issue.
Okay, I just wanted to know what information you wanted, and so I have a better idea. Thank you.
Thank you. Member Wolf?
That's okay. The answer to my question is contained in the document.
Okay. Further questions? At this point, at this time, I will again ask, is there anybody representing the respondent in the room? Seeing none, at this time, Mr. Littlejohn, you have 3 minutes to make any concluding remarks.
My concluding remark is that in 2005, the city attorney told the sheriff it's a public record. And what I would like you to do is to order the sheriff to make that information public. And take counsel yourself and find out. The sheriff's legal counsel tells you that there's not a policy. I'm telling you there is a policy against make that information public. You can easily find that out. I'll get affidavits or anything in here you want. But I would like this commission to order the sheriff's department to make the jail census public and post it and let anybody that goes up there ask for it.
Thank you. Matter is back with the task force. Is there a motion? Member Johnson.
I would like to move that the Sheriff's Department is in violation of CPRA Section 6254 F1. It's on page 34 of our packet that the City Attorney's Office says that the jail census is a public record. And in addition, on page 35, the Sheriff's Department responded that the matter in 2005 is stale, and I do not think that a public records request can become stale, so I would like to add to that motion that they are in violation of 6721B for failure to respond in a timely manner.
Second. Mr. Chair.
Member Wolf.
I just want everybody to realize that the public records request was made of the supervisor of records at the city attorney's office, and that's who responded to him on this. And it states on page 32 that under the section supervisor of records request, it states, "We conclude," meaning the supervisor of records, "that the jail census is a public record that must be disclosed under the CPRA, provided that the sheriff may withhold the names of particular inmates where disclosure of such information would endanger the safety of a person involved in an investigation or would endanger successful completion of investigation or related investigations." Once a person is in jail, I suppose the investigation is either continuing or it's over and they're serving out their sentence. Doesn't mean that it couldn't be redacted, but that the document should be presented nonetheless. Whether the census should be posted in toto, that's a different story. But the request that Mr. Littlejohn has made for the document certainly is a public record, and that is of the opinion of the city attorney.
The chair will suggest a friendly amendment to add 67.21E, failure of the Sheriff's Department to send a knowledgeable representative.
Yes.
Is there a second? Does the second accept? Maker accept?
Yes. Yes.
Further discussion? Roll call, please. I'm sorry. Is there public comment on this item? Seeing none, public comment is closed. Roll call, please.
On the motion, Member Snyder?
Yes.
Snyder, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Wolf?
Aye.
Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 6 ayes. The motion passes.
There are 7 of us here.
Yeah.
Mr. Member Costa?
Aye.
Thank you. Mr. Clerk, could you call the next item, please?
The next item is determination of jurisdiction on complaint filed by Thomas Piccarello against Supervisor Carmen Chu for allegedly violating meeting laws.
Is there a motion to find jurisdiction? Moved by Member Monte. Is there a second?
A second.
Moved and seconded. Is there any public comment on the jurisdiction question of this item? Seeing none, public comment is closed. Is there discussion? Roll call, please.
On the motion, Member Snyder?
Yes.
Snyder, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Costa?
Aye.
Costa, aye. Member Wolf? Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 7 ayes. The motion passes.
Thank you. That takes us to the substance of the motion. Mr. Piccarello, please approach the microphone. Thank you for coming, sir. You have 5 minutes.
Good evening, Thomas Piccarello. The issue before you now is whether or not a matter heard at the Budget and Finance Committee, chaired by Supervisor Chu, should have been held in closed session, and also whether or not they complied with the agenda requirements mandated by the Sunshine Ordinance. Agenda requirements both for non-closed session matters as well as closed session matters. I think I liked in the remaining 4 minutes that I have, I'll address the memorandum by City Attorney Threet. It's unfortunate he's not here. couple issues that he raised. He says it wasn't clear on page 2. I think it's in your packet number 37, his memorandum, if that helps. He said it's unclear whether the allegations, whether the entire discussion regarding the item took place in closed session or whether it was or part in closed session and part public session. Well, if Mr. Tree would have asked his colleague Cheryl Adams, who chairs the Budget and Finance Committee, she would have told him that it was all in closed session. There was no public discussion of this matter. And just to give you some detail, this is concerning the 4th Street Bridge litigation. The city is suing and being sued regarding it. The case had just failed in arbitration, and it got changed venue to Santa Clara County. But the matter that was to be discussed was whether or not the city attorney should be funded $3 million out of the general fund, which is presumably the safety net for seniors and disabled, or use his $10 million litigation fund reserve to continue the litigation on this 4th Street Bridge. As you know, despite the advice of the city attorney, it's the Board of Supervisors that make the final determination whether a matter should be heard in closed session or not. And in matters heard in closed session, there has to be a showing that the matter would cause prejudice to the city attorney for this matter to be discussed in open session. I don't believe that there would be any showing that this matter should not have been held in open session rather than closed session. And let me just add a couple of things. I did read more carefully your closed session provisions of the Sunshine Ordinance, and also, in addition to the 3 sections that I am alleging that were violated, Chairman Chu violated Section 6712B and D, which mandates disclosures after the fact of what has been discussed in closed session, and also Section 6711 for the statements that the matters are being held in closed session. None of these things were complied with, none of them at all. What's misleading about the agenda initially is it says it's talking about, proposed settlements. There's no discussion about proposed settlements with this 4th Street Bridge. This case was being transferred to Santa Clara County on a change of venue, and litigation was going to continue for probably the next year or 2. So there was no discussion about any possibility of settlements. This was just whether the General Reserve Fund was to fund the continuing litigation in Santa Clara County, or whether it would come out of the city attorney's $10 million litigation reserve fund that he doesn't want to use. So I welcome any questions that you may have.
Thank you. Is there anybody to present facts and evidence in support of the complainant? Seeing none, is the respondent present? Thank you for coming, ma'am. You have 5 minutes.
Good evening. I'm Katie Tang here on behalf of Supervisor Carmen Chu. From our understanding, Thomas Piccarello had brought up actually 3 issues, so let me just reiterate. One of them being that the agenda on the Budget and Finance Subcommittee meeting held on March 9th, 2011, item number 7 was factually misleading. His second claim that the item was heard in closed session against the individual's objection. And third, that the agenda item concerned funding of 2 city departments and not pending settlement discussions. So in response to the first issue that Mr. Piccarello brought up, we would just like to make very clear that it is actually the city attorney's office and in conjunction with the clerk of the board who work together to draft the language that appears on the budget agenda. So it's not actually our office that comes up with that language. Even though our office is not directly involved with drafting the specific language to describe the legislation, it is important to note that the agenda did indicate that a motion would be taken to convene in closed session, that it would be considered, and that the item being considered is connected to litigation. In response to the second issue, we'd like to note that public comment was considered on the motion to enter into closed session, and Mr. Piccarello, spoke during public comment, and his objection was noted as part of the public record. However, upon the advice of the city attorney and in accordance with the law of the Budget and Finance Subcommittee, they actually voted unanimously on the motion to convene in closed session on the item. And finally, in response to the third issue, the funding proposed that was on the agenda item number 7 was actually tied directly to pending litigation. So upon the advice of the city attorney, the board members on the budget committee considered the appropriateness of and voted for a motion to enter into closed session. So we feel that those 3 issues were properly addressed, and Supervisor Chu did also provide a response letter to the Sunshine Ordinance Task Force. And that's all I have here.
Thank you. Is there anybody to present facts and evidence in support of the respondent? Thank you for coming, sir. You have 3 minutes.
Mr. Clerk, could you pass these out? Good evening. I'm Rick Caldera. I'm the Legislative Deputy Director with the Clerk of the Board's office, and I'm here in support that state law permits public bodies to hold closed sessions pursuant to California Government Code Section 54956.9 and Sunshine Ordinance 67.10D provides that a policy body may, but is not required to hold closed sessions on the basis that advice of its legal counsel and on a motion and a vote in open session to assert the attorney-client privilege to confer with or receive advice from its legal counsel regarding pending litigation when discussion in open session concerning those matters would likely be unavoidably prejudice the position of the city in that litigation. Litigation shall be considered pending when any of the following circumstances exist: that a judicatory? Yes, proceeding before a court to which the city is a party has been initiated formally. So the city is a party to the Mitchell Engineering lawsuit currently pending in Santa Clara County. The 3-9 agenda for the Budget and Finance Committee identified the case. The agenda language was that the ordinance appropriating $2.8 million from General Fund Reserve to the Department of Public Works for litigation expenses. The agenda also identified the basis for the closed session. Motion that the Budget and Finance Subcommittee and the Board of Supervisors convene in closed session with the city attorney for the purpose of conferring with or receiving advice from. Thus, the Budget and Finance Subcommittee properly called and conducted the closed sessions under the laws set forth above. In addition, the Budget and Finance Subcommittee took action unanimously adopting a motion finding that it's in the best interest of the public that the committee elect not to disclose its deliberations. Thank you.
Thank you. Is there anybody else to present facts and evidence in support of the respondent? Seeing none, the matter is back with the task force. Member Johnson.
I don't really have any questions, but I watched this and then I looked up the case at the time. I don't know where it is now that it's 2 or 3 weeks later, but at the time of the meeting. And I wanted to point out a couple of things to the task force. On page 44 of our packet, at the top it says conference with city attorney, and it discusses that they're going to, the italicized language, they're going to convene in closed session for existing litigation, and it talks about they're going to have this motion. And it talks about they're going to, in which proposed settlements are being considered by the committee. And in fact, this is not a proposed settlement. Let me also say that the funding is not just for the city department, but $300,000 of it is going to go directly to Public Works. So I think that is misleading. It was not only not about proposed settlement negotiations, it was actually backdated for previous work that had already been done that they overdid their budget for. And if you click on the item itself at the budget committee and look at which I have in front of me, for item 7 that day, they go into great detail of the case and the litigation. In fact, way more detail than you could find out online, and that was all public. I have it, I got it online. So they can't really make the claim that this litigation, they were explaining the reason why they went over budget. So that really is about appropriating funds, additional funds for a department that went over budget. And they could definitely have done this not in closed session, because it, for example, in the legislative objective that explains it, the executive summary, it talks about if it's approved, the settlement appropriation request would reduce the city's general fund. And it's for the year 2010, 2011. It's past. It's not about proposed settlement. And at the time, the case was not in settlement. The trial had been moved, and they're saying that they had started prepping for trial. And it says, although the city attorney considers the expenditures of the trial preparation and the forthcoming trial, it in no way asks for anything to do with settlement. And it's all public, and and the background information gives extraordinary detail of the litigation, numbers, the amounts, the dispute, and it's therefore the proposed supplemental appropriation ordinance should be amended to provide for retroactive authorization of expenditures, nothing to do with settlement. So that first agenda item, I think, was very misleading because it mentions nothing about pending litigation or the possible litigation. But even if it mentioned pending litigation, there's this extraordinary detail that's public. It's way more, you'd have to read the complaint and the answer and the discovery and the case management conference statements to get that much detail. So I did want to point out that there were some things I think Mr. Piccarello didn't mention, and that they're reading the rules, but it's backdated to authorize their over budget for trial prep, and I think they could have discussed that in open session.
Would Ms. Chu's representative please approach the microphone? And I apologize, I didn't catch your name the first time.
Katie Tang, Legislative Aide to Supervisor Carmen Chu.
Katie Tang, did you say?
Yes.
Okay. I have a couple of questions. Now, you're stating here, as I understand it, that the item number 7 is an accurate description of the agenda item. Is that correct?
Correct.
Okay. Supervisor Chu chairs that committee, does she not?
Correct. She is the chair of the committee.
Okay, and does she not receive drafts of the agenda before they're posted in order to make any corrections?
She does receive drafts of the agenda, but again, as I would like to clarify, it is really the responsibility of the clerk of the board, the clerk's office, and the city attorney to together draft that language, and we rely on the city attorney's office to come up with the correct language.
Okay, but as far as your office is concerned, this is an accurate description, is that correct? Okay.
And if you look at the actual title of the agenda item number 7, you can
Yes,
see
I am
that it
looking at
talks
it right
about the
now.
litigation expenses.
Okay, now that's my next question. Ordinance appropriating $2,809,000 from the general fund to the Department of Public Works for litigation. You're not talking here about the litigation itself. You're just talking about an appropriation. How does that qualify for closed-door discussion?
Well, that, again, is where the supervisors seek the advice of the city attorney's office. And so based on their advice to the supervisors, we were advised that we would list on the agenda that potentially the Board of Supervisors Budget Committee would take a motion to convene in closed session, and it was decided unanimously upon among the Budget Committee members that they would convene in closed session. And as required, we do have to take public comment on that motion, which Mr. Percarallo actually attended and spoke during that public comment process. So the Board of Supervisors Budget Committee actually took all the appropriate steps to if the Budget Committee members actually decided that they, for some reason they didn't feel like it was an accurate portrayal of what the item was and that they shouldn't go into closed session, they had that ability at that time to do so, to just make that decision.
Okay,
but they decided unanimously
you got city attorney's advice, but that doesn't really answer my question. My question was, this is about a budget allocation. How does that qualify for closed-door discussion?
So again, as I mentioned, we, as the Budget Chair Office, we receive the advice from the City Attorney's Office when there are certain items related to pending litigation that we will need to potentially go into closed session. So it is not really the Board of Supervisors who makes that determination whether we are going to. We take the advice of the City Attorney's Office.
Are the members of the board familiar with the Sunshine Ordinance?
Yes.
You take the training?
Yes,
And
we are
when
required
the city,
to.
when the city attorney gives advice that might run counter to the Sunshine Ordinance or the California Public Records Act, the Sunshine, or the Brown Act,
Well, that I am,
they don't call that
I'm
into
not the
question?
judge of, but like I said, the Board of Supervisors, they depend on and rely on the City Attorney's Office for this
Okay.
information.
Thank you. Member Johnson.
Ms. Tang, I wanted to ask you a question. Do you have the description in front of you?
I have it over.
We may have a difference of opinion of whether this is an accurate description. I mentioned the italicized portion discusses settlement agreements, but you were referring to the actual description, and it says, after the bold letter, it says, ordinance appropriating $2,809,000 from the general fund reserve to the Department of Public Works. Do you know how much of that money went to the Department of Public Works?
I was not actually part of the closed session, as you know.
If I told you that only $300,000 of that was going to the DPW, would you still think that was an accurate description when $2.5 million was going to the city attorney, the people who were making the decision to put it in closed session? Do you still think that's an accurate description?
I believe that it is still an accurate description, and of course, like I mentioned before, we seek the advice of the City Attorney's Office.
All right. Thank you. So I would respectfully disagree that if only $300,000 was actually going to the Department of Public Works and $2.5 million was going to the City Attorney's Office, that is not an accurate description, and that the City Attorney's Office was seeking additional funding in closed session for its already funded fiscal year 2010 and 2011. And as Chair Nee will confirm, the chair of a committee has a responsibility too. And I understand that I did see that Chair Chu of that committee, Chair Carmen Chu, had said that on advice of the city attorney. But I do think it's their responsibility to take into consideration when they go into closed session. So I just feel like it's a budget issue, and they could have done it without discussing litigation, because they discuss it. I mean, you guys are welcome to look at this, but there's a huge detailed background of the litigation.
And if I can just add one point, the chair of the committee is...
Ms. Tang.
Oh,
I mean, you can add it in your rebuttal.
okay.
Please be seated. Thank you. Member Wolf.
Yeah, Ms. Tang, don't sit down yet.
Maybe
Just a question. Are you aware that after they had agreed to go, I'm over here.
Oh, sorry.
That if they've, after they agreed to go into closed session and then voted to go into closed session on the particular issue, that when they came out of closed session, that there was any disclosure of what happened in closed session?
So usually what happens when they go...
No, I'm just asking if they did, not what usually happens. In this particular issue,
They take a vote to whether or not to disclose what happened, and they did not disclose what happened during the closed session.
So there's no further discussion or
No.
comments from them? Okay, thank you very much.
Further questions? Ms. Tang, please approach again. I'm sorry. At this time, the respondent and then the complainant will each have 3 minutes to make any concluding and rebutting remarks. Proceed, please.
All right. So as I previously stated, our office consults with the city attorney's office, and they work with the board of the clerk of the board to draft the language for the agenda for all committee agendas and board agendas. So we rely on the city attorney's office for that information. We believe that the budget committee went through the proper procedures in terms of taking the motion as to whether to convene in closed session, took public comment on it, and afterwards voted whether to disclose the information that was discussed in the closed session or not. So we believe that we followed all the proper procedures in that respect. And, as I was trying to mention earlier, the chair of the committee is not actually allowed to make motions. She can consider motions by other members of the committee all of which had actually agreed to go into closed session, and then afterwards, all of them unanimously agreed to not disclose what had happened. So with that, I think that I've said everything that we can state on this matter.
Thank you. Mr. Picarillo, you have 3 minutes, sir.
Thank you. Just a couple of comments. First of all, the chair of the Budget and Finance Committee can't delegate her responsibility under the Sunshine Ordinance to the city attorney and or the the clerk of the Board of Supervisors. It's the Budget and Finance agenda. They're responsible for the agenda, and then the agenda needs to comply with the Sunshine Ordinance, and clearly it hasn't. If you look at the agenda, it's also misleading, and I appreciate the comments by Ms. Johnson. This matter was discussed by the city attorney with the budget analyst. Everything that I wanted to talk about was discussed between the city attorney and the budget analyst. So clearly, if there was an attorney-client privilege, it was waived when he gave all the information to the budget analyst. The problem with closed session is that I have to speculate as to what occurred in the closed session. I will say this about Chairperson Chu. Last week, there was another matter on the agenda in the Budget and Finance Committee, and the Corolla litigation. It dealt with the ADA class action against the city of San Francisco for not complying with ADA requirements. Last week, it was open session. There was no closed session. There was no distinction between what transpired last week in the Corolla litigation at the Budget and Finance and what occurred in the matter in front of you today. So I think that Chairperson Chu did learn her lesson from the complaint, but I do want an order of determination in the event that it occurs again. Thank you.
Thank you. Matter is back with the task force. Member Wolf?
Yeah, I'm finding it a little difficult is the area around disclosure after the closed session in the California Public Records Act 957.1. It's not included in our packet, but it states the legislative body of any local agency shall publicly report any action taken in closed session and the vote or abstention on that action of every member present. And it gives, a list of things that it would be regarding to, of which this is not, there's nothing that I can see with regards to money transfers or reappropriation or anything like that contained, at least in the California Public Records Act. So I find it a little difficult as to this area around the election for disclosure or not to disclose, and that, but there's no citation, as there is for the conference with the city attorney on what, if it's permitted or not. I don't see where that's allowed, that they can come out of closed session and not report what happened. That's the purpose of closed session. You don't reveal the details of what happened in closed session, but at least if a vote was taken, and if they're not going to take a vote, lots of times they won't take a vote in closed session, they'll take the vote in open session, so they don't have to deal with those open meeting issues. So I'm still thinking about possible motion. I'm not sure yet, but I wanted to state that.
Member Johnson?
I would move to find a violation of 67.7 because the description of the agenda item at the italicized talks about settlement. This was not in settlement. And then it talks about $2.8 million going to the Department of Public Works when $2.5 million of that was going directly to the city attorney's office. So it was a budget item that could have been discussed as a budget item without revealing any more of the litigation than was already revealed in a public document. 67.8 for the agenda description for closed sessions for similar reasons, and 67.10D because it was a budget-related item. They went over budget and wanted some additional funding, and it was directly related to city attorney's bills. And they could have discussed that, and in their discussion, if they discovered that they needed to go into closed session because it bled over into the litigation, they could have done that. But they never did that, and now we're not going to know why the city attorney needed $2.5 million and in addition forced the Department of Public Works to do $300,000 of their work, or why they left their own name off of the agenda item and approved a closed session that way. But as much as I appreciate that Supervisor Chair Chu of the committee...
Excuse me, is there a second?
I second it.
Okay, continue, please.
That's all. Just as much as I appreciate that, I was just explaining that the reason the motion is that I'm making the motion to Supervisor Chu is that she has a responsibility, and she's the only one that can. She could. And many times you have done this as well, where we say we have to continue this because we're unclear that the agenda was accurate. So she's the only one that could stop it at that moment. They could have moved forward because they'd already waited several months, because this is a retroactive budgetary financing issue. That's my reasoning. That's all I wanted to explain.
Discussion. Member Snyder.
Just to clarify, I mean, I think you could, so let me start over. Member Johnson, on your point about the money being actually appropriated to the Department of Public Works when a lot of it was going to the city attorney's office, I think it's a good point. I mean, I think you could assume I think it's a good point. However, I do think you could assume from their description that, you know, the Department of Public Works isn't going to pay for its own legal services. It's going to go through the city attorney. But I think that should be explicitly laid out, because it matters where when it's something as large as $2.8 million, it matters that it's the city attorney's office that's getting it specifically. And if you know how city government works, then you would assume that, well, the Department of Public Works isn't going to go out and hire its own lawyer, probably. It's going to be the city attorney's office. So I agree with your point. I just wanted to sort of add to it or emphasize it. And as far as the proposed settlements, I mean, I'm not sure it's necessarily true that they couldn't have been talking about settlements, because settlement can happen at any stage in a lawsuit. I mean, a settlement can happen the minute after a complaint is filed. It can happen the 2 minutes before trial.
It's true, but this is their request, which...
Yeah, I mean, so what Member Johnson is pointing out is that is language saying that there is trial preparation going on and that trial is forthcoming, and that.
Well, it says that the work is for a forthcoming trial. It doesn't.
Yeah.
It makes no reference to settlement.
Well, but all I'm saying is it's a modest point. All I'm saying is that it's possible, and this often happens, that you spend bajillions of dollars of money preparing for trial, and then literally the day before trial is to start, you settle.
I'm preparing for a mesothelioma trial, but the attorney that's preparing for settlement certainly doesn't bill her client without separating the two.
Well,
It's his business.
yeah.
Substance is substance.
Anyway, that's just point of clarification. I mean, I agree with you that that the description is not the ordinance requires it to be. The language, I think, is meaningful, and I think it falls short of that. I think it falls short of a meaningful description of what the discussion was about.
Member Wolf. With regards to closed session, let's just talk about process for a moment. Under 67.8.1 and in California Public Records Act 54.957.2, there is supposed to be some minutes or recordings of closed session. And when the item has no longer served its purpose, then the record can be made public. Be it as it may, under the California Public Record Act, it states the minute book shall be available only to members of the legislative body, or if a violation of this chapter is alleged to have occurred at a closed session, to a court of general jurisdiction where the local agency lies. Such minute book may but need not consist of a recording of the closed session. So I'm wondering if, it's hard to tell what exactly happened in the closed session. And this is the one, maybe in the one case where an in-camera by a court of law, a judge, could actually help make the determination for us. Because we don't know what the substance of the discussions were in the closed session, despite what the agenda item states. And if the description is incorrect, then that would be a different violation. And that's what we need to confirm.
Member Johnson.
There's been no indication as to what was done in the closed session. It was whether they should have gone into closed session at that point based on what they had. It's not, the public shouldn't have to have an in-camera review. They could have waited because their agenda was inaccurate. Their agenda was, and that the document that I have is not after the fact. That was public, and it made no reference to settlement. And in fact, Mr. Piccarello's complaint to Supervisor Chu is exactly that. This is not about litigation. This is about financing two departments who went over budget. And whether or not she had a concern, she went ahead and went into the closed session. So what they discussed in closed session is not necessarily what's being violated. Whether they should have gone into closed session based on their description is because the discussion could have gone two ways. If you're the city attorney and you went over budget, and you don't necessarily want to say that in front of the general public, you can say it's about the pending litigation that you went over budget, and then you can make it about that in closed session. You can start disclosing all these things that you shouldn't disclose. But if it's really about budget financing, you should have to say that in open session. And if the supervisors that are listening then determine that they don't know what you're talking about, then you can start detailing the litigation. But for the city attorney to put that it's the Department of Public Works that's getting $2.8 million when it's the city attorney's office getting $2.5 million, and they're able to just say that it's about litigation and start spewing all these things in closed session, they could do that every time. Every time they go over budget, who's going to ever have access to how often they go over budget? Because there could come a point where they could say, wait a minute, we can see that this is not something we can discuss in public.
Member Wolf.
I completely understand that, but it's, by the same token, that's conceptual. They should do this. Of course they should do this. This, could have been done. Of course it could have been done. But we're at a point here where a complaint has been made, and the complaint has been defended and responded to, and we still don't have all the facts.
No, it's not about what happened in closed session.
But I understand that, but it goes both ways. The question is, the real question is if there was something that was discussed that was of substance to the litigation, okay? Then
the question is,
I'm speaking right now, okay? Then the description on the agenda is incorrect, okay? Because it should have not discussed anything around budget items. It should have had this written in there a description about something around the litigation, the substance of the litigation. So by going forth and listening or getting some report as to what the substance of the closed session was, if the substance of the closed session was specifically substantial to the merits of the case or details of the case, then this agenda is incorrect. And there you have another problem. That's what I'm trying to point out here. I understand Member Johnson's perspective and what she's talking about. I'm bringing up a different issue. Okay, I'm bringing up an issue of they did go into something may have been said at the conference that may have been discussed something around details, but in number 7 it doesn't discuss anything around details. It only discusses appropriating of money, which is not grounds for a closed session. So that I'm just saying that if you have an in-camera review, then at least it confirms whether the description is or is not. It's just another angle, that's all.
Further discussion? Is there public comment on this motion? Seeing none, public comment is closed. Further discussion? Thank you for coming, sir. You have 3 minutes.
Thank you, members of the task force. My name is Judson True. I'm an aide to Board of Supervisors President David Chu. And I'm here on the upcoming items, but obviously this is an issue of great concern to the board. And as the aide for the president of the board, I thought I should make a public comment in defense of Chair Carmen Chu and her aide and the comments that she made and made by Rick Caldera from the clerk of the board's office. I think that there were a lot of interesting items under discussion, and I think a lot of it got to the fundamental issue of whether or not there was a legitimate reason for the Board of Supervisors Subcommittee on Budget and Finance to go into closed session to take advice from the city attorney in this lawsuit and to appropriate this money related to it, or in fact to recommend to the full board whether or not this ordinance should move forward. And I wanted to make a couple quick points related to that. First, I don't believe that, I'm not sure who the correct sort of target of the complaint should be, but I don't believe that Chairwoman Chu should be the target. She does not have power to make a motion as chair of the committee, and if there was desire to make a motion responsive to the public comment about the closed session, it'd be possible that another member or the city attorney could intervene, or the clerk, but I don't believe that Chair Chu is responsible in that instance. And I do think that the agenda is accurate, by the way. And then I would say in response to one of the members' comments that there was a lot of focus on the settlement issue. This is litigation, it's existing litigation, and the language in the agenda makes very clear that existing litigation is an appropriate reason to go into closed session, and it's very clearly detailed in the title of the ordinance. It's Santa Clara Superior Court case between Mitchell Engineering, Obayashi Corporation versus CCSF, and that's very clearly stated, and it follows naturally from the description to the language of the ordinance. I did also want to mention in regard to Member Wolf's comments that the minutes, I just looked at the minutes for that meeting, and they did say that the committee moved to forward the item without recommendation to the full board, and so that was reflected. The whole purpose of a closed session conferring with the city attorney is to get legal advice related to existing litigation or a settlement. So to disclose anything, the board had the power to disclose something, the comments, but the board does clearly have the power to vote not to disclose the substance of the discussion. That is the very purpose of the board in this case, or other city officials conferring with council. That is fundamental to the work that they need to do to protect the city and county. Quickly on the amount of the appropriation, it's clear that this is for litigation expenses, and it's clear that the Public Works and the city attorney, that this ordinance is entirely accurate in the money being appropriated, and then the city attorney can work order and move that money or the DPW can move that money to the city attorney to pay for litigation. The DPW expenditures related to litigation are clearly staff collecting documents and such like. So we'd ask you to not find a order of determination here.
Thank you. Is there further public comment?
It's kind of a farce what this guy is saying. He's saying that the leader of the committee isn't responsible for what's happening. Okay, thank you. The other thing too is I'm wondering if there was any audio recording of this meeting.
Thank you. Is there further public comment? Seeing none, public comment is closed. Is there further discussion on the motion? Member Johnson.
I just wanted to point out that the city attorney was asking, they were not commenting on, they were not giving advice on the litigation. I have the document that's the executive summary of what they were asking for, which is online. Anybody can look at it. And they a combined total of approximately $319,000. 11.4% of the 2.8.9 is projected to be expended by the city attorney and DPW retroactive from December 1st to March 8th. They were 2011. They were not commenting on future pending litigation. And there is a question, I think, as to whether that budget, you can look at it if you want, as to whether that budget was there could have come a point where maybe the city attorney would have had to divulge something that they did. If the supervisors needed to know why they went over budget, perhaps that would have revealed some strategy. But they went over budget. And it just seems like that means every time the city, the problem with basing it on whether or not the city attorney stands up and discloses some confidential information is that every time then that they want to do every time they go over budget, they can always do that because they're the ones that have all of the facts. But going into closed session beforehand, before you reach that point, so that everybody in full view can see the confusion that might happen if they don't go into closed session, is something that I think is essential to open government when we have to have budget cuts and all of that kind of thing that are going on. And in addition, Mr. Picciarello brought up in his comments that there's a reserve that the city attorney has for litigation expenses that maybe go over. I'm not familiar with that, but being in closed session, the public has no opportunity to say, hey, how come you're not using this? If they know about it, or bring it to the public's attention.
Further discussion?
Mr. Chair.
Member Wolf.
I have a question. Since we don't have our legal counsel here, I'll want to ask a question of our other legal counsel, Member Snyder. On this document that's from the Budget and Finance Subcommittee, it states here under fiscal impacts, although the city attorney considers the expenditures of the trial preparation and the forthcoming trial by the city attorney's office and DPW to be privileged and confidential, the city attorney and DPW will provide such details to the Budget and Finance Committee on a confidential basis if requested. Is it, in your experience, that expenditures of trial preparation are considered privileged?
Well, they could be, yeah. I mean, just the amount, although in this case I don't think the amount alone is. They've released it, as a matter of fact. But I think that's not outlandish at all, because they could be talking about what they're going to spend their money on and what they're going to spend their money on specifically.
Right.
It's already been allocated for
yes,
a specific
it says
purpose. So the reasons that the money was spent. You know, if they spent 9/10 of that money on discovery, that would tell the other side a lot. If they spent, so what I'm saying is the cost breakdown could definitely be an attorney-client privileged information.
I'm a little, well, also the money that's being spent is public money.
Yeah.
So
yeah.
the public has a right to know in some way, shape, or form, before, after, in between. The question I have regarding this, it says the proposed ordinance would appropriate the $2,809,000. How is it already spent? I'm not understanding how it was already spent.
Because they're asking for money for work that was done in trial preparation and trial, right here, retroactive, from December 1st, 2010 to March 8th, 2011. And the meeting was held on March 9th, 2011, so they're not asking for money for future litigation, nor have, I agree with Member Snyder, but what I disagree with about the closed session is that there is no evidence that that was required, that it was required that they reveal that it was spent on discovery, et cetera, and I think they could have refrained from closed session until they knew that that was the case, since it was in the past. And also, 6710 is on page 42 of our packet, and I would like to point out that even though several people have discussed whether or not Supervisor Chu, as chair of that subcommittee, can change the agenda or hold the agenda or move something over, 6710 says closed sessions permitted topics. A policy body may, but is not required to, hold closed sessions. So there is some choice that the policy body could make.
Member Wolf.
It's just a last point that whether or not the chair has the ability to make a motion, it's the chair's responsibility to determine whether a motion that has been made is correct or not, and can overrule those motions.
I'm not so sure of that. But
That's what the purpose of appealing the decision of the chair motion is for.
Well, that's right. So the chair doesn't have the ultimate authority on that.
That's right, but the chair has
can
the
be
ability
overruled
to.
by his or her committee.
That's all right, but the chair does have the ability to object or to make a correction of a motion that's been made.
That's true. Further discussion, Member Costa.
Yeah, on that point, I guess I would also just like to make a note of the fact that it is simultaneously deeply frustrating that the entity that is supposed to be, whose responsibility it is to be giving advice to the chair and that committee and other policy bodies about things like closed sessions, if they did indeed appeal to the city attorney for that advice and got advice that it was the right thing to do, that's deeply frustrating that they gave them incorrect advice. And I realize that our hands are sort of tied about doing anything about that here, but I guess I would just like to sort of note that the blame is not unshared, it seems.
Further discussion. Roll call, please.
On the motion, Member Snyder?
Yes.
Snyder, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Pass.
Member Johnson?
Aye.
Johnson, aye. Member Wolf?
Aye.
Wolf, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, the motion passes. There's 7 ayes.
Thank you. This matter is referred to the Education Outreach and Training Committee, and before we proceed, I want to go back to item number 2, complaint number 11014. That is referred to compliance and amendments. Item number 4, complaint number 11015, that is referred to compliance and amendments. And again, 11017 is referred to the Education Outreach and Training Committee. Thank both sides for attending. Would you call the next item, please?
Yes, Mr. Chair, the next item is determination of jurisdiction on complaint filed by Charlotte Lawn against Supervisor David Chu, Supervisor Carmen Chu, and Supervisor Eric Ma for allegedly failing to respond to a public records request.
Is there a motion to find jurisdiction?
So move.
Is there a second?
Second.
Moved and seconded. Discussion. Is there any public comment on the jurisdiction question of this item? Seeing none, public comment is closed. Roll call, please.
On jurisdiction, Member Snyder?
Yes.
Snyder, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Yes.
Wolf, aye. Member Johnson?
Yes.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 7 ayes. The motion passes.
That takes us to the substance of the complaint. Is Ms. Lawn present? Is the complainant present? Is there anybody here to present facts and evidence in support of the complainant? Mr. Rustum, was the complainant informed about tonight's meeting?
Yes, Mr. Chair.
And did she respond that she would not be here?
She did not respond to my...
Okay. In that case, the chair would, I am inclined to go forward with this. Without objection? Is there anybody to present facts and evidence in support of the complainant? Seeing none, is the respondent present? Please approach. Thank you all for coming. You have 5 minutes.
Katie Tang from Supervisor Carmen Chu's office. First of all, I just want to say that Supervisor Chu takes all inquiries from the public very seriously. It is, in fact, only because of the email that we received from the Sunshine Ordinance Task Force and notification that she first learned that there was actually an outstanding sunshine request in our office. So after receiving the email, we did review our office procedures on correspondence and found that our volunteers actually had inadvertently failed to notify the supervisor and the legislative aides of the sunshine request. So as a direct result, we have actually changed our office procedures so that all the letters submitted to our office are also also reviewed by the legislative aides who are trained on the Sunshine Ordinance. And our goal is to make sure that we can avoid these miscommunications in the future. And also, specifically in response to the request, the Sunshine request, 1, the city labor agreements and side letters with Local 16 and FX Crowley. 2, hiring lists with Local 16 and FX Crowley. 3, crew lists with Local 16 and FX Crowley. And 4, permits with Local 16 and FX Crowley. Our office does not have any documents in direct response to the Sunshine request. We believe that the Department of Human Resources instead would probably be the more appropriate organization to respond to that.
Thank you.
Hi, good evening. Lynn Shaochin, Legislative Aide for Supervisor Eric Marr. Like Supervisor Chu's office, our interns sort the incoming mail and did not pass this message on to us. And so we do take Sunshine requests seriously and do fulfill them in a timely manner when they are received. However, we only found out about this one when we received the complaint. We also do not have any of the documents responsive to this request.
Thank you.
Hello, members of the Sunshine Ordinance Task Force. Judson True again from President David Chu's office, the Board of Supervisors. Similar situation to my colleagues, except in this case we did not, as we responded to the task force, my colleague Victor Lim, on April 5th, we searched our paper records and were not able to find them at that time. I actually did find it subsequent to that in my particular files, and I apologized to the complainant about that and had not seen the second page of the letter that asked for the Sunshine materials, and we immediately responded actually back in April to inform her that we were open to assisting her, but we didn't have any responsive documents. I also had subsequent conversations with the complainant, both at the last task force meeting where the item was continued and one conversation after that. And my understanding after speaking to her was that she had issues with the board's appointment of Mr. Crowley to the Port Commission, and I explained, and then had various human resources type complaints against Commissioner Crowley, and I referred her to. I just basically said that we had no jurisdiction to help with that. Those are civil matters or pursued through her union, and that there was nothing else that we could do related to those issues. So that's where we left it. Thank you.
Thank you. Thank all three of you. Is there anybody here to present facts and evidence in support of the respondent? Seeing none, I would ask the respondents to, if there are seats in the front row, please take them. When parties in interest, when your case is being heard, it's a good idea to sit in the first or second row. That way, if we call you up for questioning, you don't have to feel too much like a yo-yo. Sir?
Yeah, I think the problem that I'm having is
Sir, we haven't called for public comment.
Okay,
yet.
well, I was going to come for the respondent, right? For the complainant, right?
No, you're not the complainant in this matter,
well,
sir.
I was going to.
Sir, please be seated. Okay. The matter before us, item 11018, that is before us. Does any of us have questions for the respondents?
I have a question for our clerk.
Mr. Wolf? Wolf?
Through the chair, I'm looking at the original complaint, and it names every single supervisor. Were they all notified?
Through the chair, this complaint was made, I believe, somewhere in late January, and I had an ongoing conversation with her, and I asked her for documents in support of her complaint, and she's told me that she wanted to go with only 3 supervisors.
I'm sorry, she told you?
That she wanted to file the complaint against only 3 supervisors because most of them had been termed out.
Thank you. Member Johnson?
That answers my question to, that was the same, I had the same question, why there was everyone named.
Okay.
Only 3.
Member Snyder?
I have a question for the respondents. I'm not sure which one would be the best to ask. Maybe all 3 of you. Could you all come up? I'm just wondering that, so you've all said that you don't have the records. Did you ever have these records? They're no longer there, or these are records that your office has simply never had?
As we stated very clearly, we've had different situations here, but in our office, Supervisor Carmen Chu's case, after we received the complaint notice from the Sunshine Ordinance Task Force, we went back and looked at our files, and that was when we discovered the letter, which was actually the second page where the Sunshine request is actually made. And our interns, unfortunately, just did not notice the Sunshine complaint and did not notify us. But we have since changed our procedures.
Yeah, no, I understand that. What I'm asking, though,
Member Snyder.
yeah, I'm asking it what she was asking for, the city labor agreements, hiring lists.
We do not have in our possession those items.
Yeah, no, I understand
As
you
a
don't
regular
have
matter,
them.
of course.
You've never had them, is
No,
what
we
you're
would
saying.
not keep those unless I had some particular reason to keep the Local 16 MOU or something like that. I don't have it. We didn't have any files like that.
All right.
Do you know who would have those files?
The Department of Human Resources would.
Okay, and
most
was
definitely have those files.
and was Ms. Lawn directed to the Department of Human Resources?
I cannot speak to that. I do not know.
Member Wolf?
All right. Does an MOU like this have to be approved by the Board of Supervisors?
All labor agreements would probably have to be approved by the Board of Supervisors, but I don't have those records in my possession.
Do you, whether or not, do you know if the Board of Supervisors had approved or
I
had a
actually
discussion around
do not know if the board has a labor agreement with Local 16.
Okay, thank you.
At this time, Member Washburn?
I have questions for the aides for Supervisor, the Chairman Chu, and also Supervisor Marr. Ms. Tang said that Supervisor Carmen Chu has put into place procedures so that this type of thing doesn't happen again. Every single one of your offices, missed the letter. And so that's who knows how many other letters were not seen. So this is a potential problem. So I'm wondering, for the other two of you, has your office put into place procedures so that letters don't get lost?
To Member Washburn, Judson True from President Chu's office, we do have procedures in place to handle all mail. My colleague Victor Lim, as Sunshine requests are directed towards him. I receive other correspondence or unknown correspondence, and so it was in my possession, and it was simply my oversight. So, it's a mistake that I apologize for and apologize to the complainant for. But I have no reason to believe that we do this as a matter of course, and we regularly respond to Sunshine requests. And it was because it was on the Sunshine piece was mentioned on the second page of a letter that we didn't see as being within our jurisdiction that was directed to all board members. That's why I missed it.
Okay.
It's not an excuse. It's just why I think I missed it. So.
Okay. All right.
The mail comes into our office. This is Lin Shao Chin from Supervisor Marr's office. The mail comes into our office, and we sort them in different piles by meeting agendas, correspondence, invites. Occasionally, there's mail that will come in where the interns may not know where to sort it, and I think that this was one of those cases. If you look at Ms. Lawn's letter, the first page of the letter, she's talking about issues with Local 16. This doesn't necessarily fall into one of the categories of mail sorting that we have, and it isn't until halfway down the second page where there is a Sunshine request. So this is the first time that this has happened in our office. I don't really have a reason to believe that we are missing a lot of mail, but we have instructed our interns to be more careful and read things more thoroughly and make sure that Sunshine requests do get directed to a legislative aid.
Okay, thank you.
Okay. At this time, the respondents will have 3 minutes to make any concluding remarks.
Just thank you very much to the task force for hearing our explanations. And again, I wanted to reiterate President Chu's commitment to open government into sunshine, and we are responsive to quite a few requests, and did apologize to the complainant. And as soon as the complaint came to our attention, said we had no responsive records, and did respond immediately. So I wanted to note that for the record, and that's pretty much it.
Thank you. The chair will again ask, is there anybody here representing the complainant? Seeing none, the matter's back with the task force. Is there a motion? Sir, please be seated.
We haven't done public comment.
Please be seated. Is there a motion? Member Johnson. Talk about Freudian slips. Member Johnson.
I'm very tickled. You know, I appreciate that they've changed their rules, but it's in my normal fashion, I'll try to be blunt. It's suspect that this particular letter was missed by 3 different supervisors' office. So I understand that they don't have any documents, but I would like to see an order of determination with the motion to find violation of 6721B for failure to respond. It's not. It's an interesting argument that it's on the second page, but a sunshine, you know, it's not. There's nothing in the sunshine ordinance that says it has to be an obvious sunshine request.
Is there a second? The motion dies for lack of a second. This matter is concluded. Thank both sides for attending. Before we move to the next item, the chair will call a 5-minute recess. We're back in session. Mr. Clerk, could you call the next item, please?
Yes, Mr. Chair, the next item is determination of jurisdiction on complaint filed by Charlotte Lawn against the Film Commission for allegedly failing to provide requested information and being untruthful about it.
Is there a motion to find jurisdiction? Is there a second?
Second.
Moved and seconded. Discussion. Is there any public comment on the jurisdiction question of this item? Seeing none, roll call, please.
On the motion, Member Snyder?
Aye.
Snyder, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 7 ayes. The motion passes.
That takes us to the substance. Is the complainant present? Is there anybody to present facts and evidence in support of the complainant?
Chair Neem,
Member Johnson.
point of order. We didn't take public comment on the last item.
No, we did not. Your point of order is well taken.
Just because Mr. Pitts had gotten up. That's
Okay. Is there public, let's go back then, and I apologize. Is there public comment on item number 11018? Charlotte Lawn against Supervisors David Chu, Carmen Chu, and Eric Marr. Mr. Rustum?
Mr. Chair, I saw the both of them entering the escalator.
the elevator.
Elevator, sorry.
Okay. Public comment on item number 8, complaint number 11018 is closed, and we will proceed then with item number 10, complaint number 11020. Is the complainant here? Complainant is not. Nobody to present facts and evidence in support of the complainant. Is the respondent present? Please approach. The inclination of the chair is to proceed with this. Thank you for coming. You have 5 minutes.
Thank you. The complaint seems to consist of 3 items. The first is that we failed to provide information. This, we believe, is without merit because we received information requests on December 28th of 2010 and supplied a response on January 3rd of 2011, which I have provided you with. Not only did we give her all responsive documents we had, we suggested other departments that may have documents that we didn't have, and we told her about documents we had that may partially satisfy some of her requests that she could request from us. Number 2 is that she complained that we failed to provide all requested information. We did make a clerical error in the dates of the response that we gave her. We were notified of that error by Ms. Lawton on January 31st, and we responded on February 2nd. It was a clerical error. I apologized. I left 1 year off out of my response. And then finally, number 3, she said that the complainant says that we were not truthful about not knowing which shows are unionized. I was truthful. We don't have a record of that. We don't collect information from every permit. We don't collect information from any permittee on whether or not they have a union contract. So therefore, we didn't have any documents that we could respond with. We do have crew lists for some productions. So in our first response to her, we notified her of this and said, maybe some of that would help you, in the hopes that she could review the crew list, see a name from Local 16, and then know that Local 16 had been on the job. In her subsequent request, she did request those. We submitted all of them with redactions of the personal cell phone numbers and emails, and it is our belief we fully complied with her request.
Thank you. Is there anybody to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force. Mr. Rustum?
Mr. Chair, could you identify yourself?
I'm sorry?
Would the respondent identify herself?
Laurel Barsotti from the San Francisco Film Commission. Sorry.
Okay. Thank you. Task force? Okay, Ms. Barsotti, if you wish, you have 3 minutes to make any concluding remarks.
I have none.
Thank you. Is there a motion?
Just out of consistency.
Member Johnson.
Out of consistency, I understand they don't have documents, but it's difficult for me not to make a motion for 6721B for failure to respond in a timely manner. They did? It says December 28th.
She responded on January 3rd.
Yeah.
Please talk into the
sorry.
microphone, members,
Sorry.
please.
I believe she testified that they responded on January 3rd. I don't think that's in the
Perhaps
written
maybe
record.
This says April 5th, but maybe that's to us, and I
Yeah.
misread
Yeah,
that
that's
you're.
ours.
I might have misread. I apologize. I misread the dates. April 5th is to us, not to.
Right.
But they received. She submitted it on March 11th, not December 28th.
No, I received it on December 28th and responded on January 3rd. I received a follow-up complaint on January 31st, notifying me that I had made an error in how much I had responded with, to which I rectified the error on February 2nd.
I withdraw the motion because I misread that. I thought the April 5th letter was her response.
Is there a motion? Is there public comment on this item? Seeing none, public comment is closed. There being no motion, this matter is concluded. Ms. Barsotti, thank you very much for coming. Mr. Clerk, could you call the next item, please?
Yes, Mr. Chair. Item 11 is determination of jurisdiction on complaint filed by Deborah Benedict against the nonprofit Tide Center for allegedly violating Admin Code Chapter 12L.
Is there a motion to find jurisdiction? Is there a motion to find jurisdiction?
So moved.
Is there a second?
Second.
Moved and seconded. Discussion.
Mr. Chair.
Member Wolf.
Is there any correspondence from the city attorney, our legal counsel on this? Not inclined.
Mr. Rustum?
Through the chair, Member Wolf, I don't believe so.
I don't recall having seen any. I did make some notes of my own, but I don't recall having seen any memorandum from our deputy city attorney.
There hasn't been. Yeah.
Is there public comment on the jurisdiction question? Seeing none, roll call, please.
On jurisdiction, Member Snyder?
Yes.
Snyder, I. Member Manny?
Yes.
Manny, I. Member Washburn?
Yes.
Washburn, I. Member Costa?
Yes.
Costa, I. Member Wolf?
Aye.
Wolf, I. Member Johnson?
Member Johnson?
Yes.
Johnson, I. Member Nee?
Aye.
Nee, I. Mr. Chair, we have 7 ayes. The motion passes.
That takes us to the substance of the complaint. Ms. Benedict? I'm sorry.
Chair Nee, sorry.
Member Monet?
I just realized that it's that the respondent is the Tide Center. That's correct for this complaint, and if that is so, then I wish to recuse myself because of a project that my organization may or may not be continuing with the Tide Center. So.
Okay, the chair will entertain a motion to recuse member Manek.
So moved.
Is there a second?
Second.
Moved and seconded. Discussion on the recusal. Public comment on the recusal. Seeing none, roll call, please.
On recusal, Member Snyder?
Aye.
Snyder, I. Member Manny? I'm sorry. Member Washburn?
Aye.
Washburn, I. Member Costa?
Aye.
Costa, I. Member Wolf?
Aye.
Wolf, I. Member Johnson?
Aye.
Johnson, I. Member Nee?
Aye.
Nee, I. Mr. Chair, we have 6 ayes.
He gets to vote.
Do I? Maybe I don't.
On Member Manny?
Aye.
Member Manny, aye. Mr. Chair, we have 7 ayes.
Until she's recused.
Chair Nee.
Thank you.
I
Member
actually
Costa?
worry that perhaps I should as well, which I didn't realize would take us below quorum. But
If, well, that takes us below quorum.
I realize. Well, I am open to hearing the task force weigh in on this.
Why do you wish to recuse?
Similar sort of organizational relationships.
Okay. Is there a motion to recuse member Costa?
So move.
Is there a second?
Second.
Moved and seconded. Discussion. Is there public comment on the recusal of Member Costa? Seeing none, roll call, please.
On the motion, Member Snyder?
Yes.
Snyder, aye. Member Washburn?
Aye.
Washburn, aye. Member Wolf?
Aye.
Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Member Costa?
Aye.
Mr. Chair, we have 6 ayes to recuse, Mr.
Okay,
Member.
that takes us below a quorum, which means that on this particular item, this particular item will be continued to our regular meeting of May 24th.
Mr. Chair?
Member Wolf.
I think it would behoove us to send a communique to all the members that if they know that they may have a conflict before the meeting, after having received the agenda, that they notify our administrator, so we can, if we know that we're going to have a limited quorum, or it may, you know what I mean? Thanks.
Okay.
That's going to go.
Okay. Members Costa and Manek, could you please return? Because of the lack of quorum, that matter was continued. So we move on to item number 13. Mr. Clerk, could you call that item, please?
Yes, Mr. Chair. Item 13 is determination of jurisdiction on complaint filed by Deborah Benedict against the nonprofit Lutheran Social Services for allegedly violating Admin Code Chapter 12L.
Okay, is there a motion to accept jurisdiction?
So moved.
Second.
Moved and seconded. Discussion. Is there public comment on the jurisdiction question of this item? Seeing none, public comment is closed. Roll call, please.
On jurisdiction, Member Snyder?
Yes.
Snyder, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 7 ayes. The motion passes.
Thank you. That takes us to the substance of the motion of the item. Ms. Benedict, please approach the microphone. Thank you for coming. You have 5 minutes.
First, I want to say thank you to all the commissioners and chair for allowing me another opportunity to bring this forward. Unfortunately, I had surgery, so I wasn't able to even read an email at that point. This is possibly, again, one of those situations where the notice was sent in the 30 days. It was no problem. I got up extremely early to get ready to go to this and was at the meeting. I believe that you have the letter with the, or the information with the assistant pastor at the church, which is immediately adjacent to Lutheran Social Services offices, as well as the transit transfer that that indicates that I was up in the area. So I guess the issue is that my concern is that an organization has noticed that they have a meeting, and unless someone actually physically goes to the meeting or wants to go to the meeting, there's no way for this commission to know whether or not a meeting has occurred. And if a meeting has not happened, then the second notice for, hopefully they're following enough of the rules to know that they have to have a second meeting that's open to the public, so that when that happens, then those are considered their 2 meetings, which basically deprives the public of an opportunity to have, as per my understanding of the ordinance, to have 2 opportunities to go to board meetings. Subsequent to the communication that you have in your file, I have sent emails in response to the email that arrived from Ms. Nilsson, and explained that not only I had surgery and I I certainly empathized with the length of these meetings and said that, of course, neither you nor she nor any of us really has any opportunity to shorten a meeting. But that it's important to note that I wanted to make a marker of this so that not only to give Lutheran Social Services opportunity to plan for those 2 meetings within the remaining months of the year, but also to have a marker to indicate that one of the 2 required meetings had not in fact occurred, and that I had made the effort and gone up there to be at that meeting, and that it had not in fact happened. So my primary goal and purpose was as a marker. I don't know any other mechanism to let the task force know whether or not a meeting hasn't occurred, except to make a complaint. So that's why I did that. Thank you.
Thank you. Is there anybody to present facts and evidence in support of the complainant? Seeing none, is the respondent present? Thank you for coming, ma'am. You have 5 minutes.
Thank you. Good evening. I'm Nancy Nielsen, currently serving as co-director of Lutheran Social Services. As I indicated in my response to your notice, I was extremely apologetic for a clerical error that occurred. We did, in fact, as we always do, because we have been trained in the requirements of the Sunshine Ordinance in San Francisco, and it is a requirement of all our contracts. We do, in fact, post notices of all of our public board meetings. Unfortunately, on this particular meeting, the notice that went out noticed the meeting as Saturday, March 13th, when in fact the date of the meeting was Saturday, March 12th. Unfortunately, Ms. Benedict chose that meeting to attend and obviously assumed that was the correct meeting, although we would never have met on a Sunday. And she did, in fact, as she indicated, go to Concord and did find in talking with the people who rent the space from us on Sunday mornings that our board meeting had, in fact, occurred the day before. We did have the meeting. It was a mistake in the notice that was filed, noticing the public meeting. One change that's been made in procedures with my administrative staff is that all public notices from now on will also be copied to me, as well as to the required postings, so that I can also verify that the information in the notice is correct. My apologies that happened. It was not anyone's intent. The meeting was not changed. The meeting did, in fact, occur on the day it was scheduled.
Thank you. Is there anybody to present facts and evidence in support of the respondent? Seeing none, matters with the task force. Okay, at this time the respondent and then the complainant will each have 3 minutes to make any concluding or rebutting remarks. Ms. Nielsen?
I don't know that I have anything else to say. My initial response indicated my sincere apologies to Ms. Benedict for inconvenience. We certainly would not want anyone making that trip. I make it daily. I know how long it is to Concord. So we do apologize for that, and we do not expect that it would happen again.
Thank you. Ms. Benedict?
Again, thank you. I just wanted to note that I only made the complaint related to this because of the marker that I wanted to suggest, so that there would be an opportunity for myself or any of the other members of the public that might want to attend the meetings. And that really is the purpose. Thank you.
Thank you. Matter is back with the task force. Member Wolf.
Yeah, I guess I didn't, because we don't have any legal counsel advice here. I'm not sure if it was agreed that this is a 12L issue.
Member Wolf? I'm sorry, Member
Snyder.
Member Snyder.
I mean, so there's
getting late.
Do you mean that whether 12L applies or whether there's a violation?
Yeah, I mean, this is a nonprofit organization.
Yeah.
I don't know if they get money from the city. I don't know, I guess we can ask.
Yes, we are contracted with the Department of Public Health.
Can you come closer so we can hear?
Sorry. Yes, that's part of why we fall under this jurisdiction.
Do you receive more than $250,000?
Yes,
Okay.
we are contractors with
All
the
right,
city.
thank you. So you're under 12L. Okay, thank you.
So, I mean, one provision of 12L, the notice provision of 12L requires that the nonprofit provide, the wording is, shall provide the public with notice of each designated public meeting at least 30 days in advance of the meeting. It doesn't explicitly say that it has to be the right date listed, but that's, I think, a necessarily implied part of requirement of the rule is that the date be accurately listed. I mean, so I think if the task force wanted to find a violation, I think it could. I think one of the roles of this body is to hear complaints so that, one of the roles of the body is to serve the function that Ms. Benedict outlined, which is to sort of alert the public at large and the nonprofit agencies or the city agencies who are subject to these rules that they need to follow them. It sounds to me from the testimony from Lutheran Social Services that they understand that, and so maybe the task force could find no violation because it's a little bit squishy. It's not necessarily direct violation of the rules. If it did want to find a violation, I think there's solid ground for that. But I think that it's clear that the function of the Sunshine Ordinance and this body and these hearings has been served. I think the question is just whether the task force wants to make it official and find some kind of a violation.
Member Wolf?
The only concern I have about this is that there is a requirement that the agendas be accurate. And this would be a case where it wasn't accurate, and we've also been guilty of that ourselves from time to time, where the wrong date has been put on an agenda, and we've had enough time to make the correction because somebody noticed it before the meeting. But I think that it's important to keep the precedent and to move forward.
Is there a motion?
So without knowing what it would be,
it's 12L
4A1.
Oh, that's a different one than I was
12L 4A1. That's what I have.
Okay, then I'll move to find a violation of that. It's not terrible.
Member Snyder?
I guess.
You have a different...
Well, 12L4A1 just says that they're supposed to hold 2 public meetings per year, and that they... and then it lays out specifics about what they're supposed to address at that meeting. I was going to say 12L4D1. Each nonprofit organization shall provide the public with notice of each designated public meeting at least 30 days in advance of the meeting. I could probably go either way.
Would that be, has there been a second to Member Wolf's motion?
No.
Okay. Member Wolf, is that an acceptable substitute, 12L4D1 instead of A1?
12L4D. Well, no, because they did post the agenda properly. The agenda it's just the information, it was not accurate.
Right, but I don't think A1 gets at that either. I think the closest we get is D1. That's what I was saying, is that there's no literal requirement that it has to be accurate. So I was trying to find this, but that's of course a requirement, because if it weren't accurate, then nobody would know where to show up. And so I was trying to find the section that got closest to...
I understand what you're saying.
Yeah.
One moment. I'm reading this.
So what is the motion?
Okay, I would say, yeah, D2.
D2.
You mean... Oh, yeah.
Is that what you were saying, D2?
Actually, I said D1, but I think you might be right. D2 probably works better. My apologies.
Is there a second? Motion dies for lack of a second. This matter is concluded. Thank both sides for attending. Ms. Nielsen, if I could, though, even though no violation has been found, in the interest of fulfilling that particular meeting obligation, and this is just a suggestion, what might make sense is to, again, repeat that meeting, rescind all actions that were taken on March 12th and revisit the entire agenda. You could do that. You don't, because there has been nothing, there is no order of determination coming forth from the task force, we can't order that. There's been no motion here. However, you might consider doing that, just in the interest of meeting your public obligation and satisfying your constituents.
We have 2 more meetings this year that can be open to the public.
Thank you. Thank both sides for attending. Is there public comment on this item? Thank you for reminding me, Mr. Piccirillo.
I think you should just send her, documentation and our letters to remind her that there are several rules and laws regarding, conduct of meetings and information regarding being on listservs and things like that. Just a notice of friendly, maybe an outreach to remind her the policies and procedures of the Sunshine Ordinance.
Thank you. Is there further public comment on this item?
Thomas Piccirillo. I'm disappointed that there wasn't a second on the motion by Mr. Wolf. There was a clear violation of the Sunshine Ordinance. The apology was appreciated, but there was a violation of the Sunshine Ordinance. And so, should have found the violation. You see, in order to show willful disregard of the Sunshine Ordinance, you have to, I believe, show a track record of previous violations. So when you let somebody off with an apology, there's no record of previous acts. So I would have preferred to have you find a violation and then refer to the Education Committee, and perhaps there could have been some lecture on the Sunshine Ordinance to the Lutheran Social Services. Thank you.
Thank you. Is there further public comment on this item?
David Pilpel, former member of the task force. I just wanted to caution the members of the body not to read more into 12L than exists. 12L was a carefully crafted compromise that imposes certain very specific burdens on nonprofits that contract with the city at certain levels, and not anymore. So you may want other things to be in there and be correct and have all kinds of fun things happen, but if it's not in 12L, it's not something that the city can enforce, and I would encourage you to just look very narrowly to the language of 12L. Thanks.
Thank you. Is there further public comment on this item? Seeing none, public comment is closed. Again, this matter concludes. Thank both sides for attending. Mr. Clerk, could you read the next item, please?
Yes, Mr. Chair. Item number 15 is determination of jurisdiction on complaint filed by William Clark against the Arts Commission for allegedly not providing information related to an employee's job reclassification.
Is there a motion to find jurisdiction?
So moved.
Is there a second?
Second.
Moved and seconded. Discussion. Is there public comment on the jurisdiction question of this item? Seeing none, public comment is closed. Roll call, please.
On the motion, Member Snyder?
Yes.
Snyder, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 7 ayes. The motion passes.
That takes us to the substance of the complaint. Mr. William Clark, please approach. Thank you for coming, sir. You have 5 minutes.
Hi, thank you. I just want to make you aware of the fact that there is no representative here from the other side, and I think there should be one here, since he found out on Friday he knew he wasn't going to be in his office for 2 days, and he should have notified his assistants to take his emails so that he could be aware of this. And his representative was here last month, and told him that we were going to have one calendar. So I think you should go ahead with this. What this is in regards to is I found out that Miss Evelyn Russell's job code section was changed from 14, I believe it was a 1426 step 3, which was a senior clerk typist, to a 3541 step 5, which was a museum curator. And she was the assistant to Howard Lazar at the Arts Commission. So I requested an information and a document request as to when her job code classification was changed and why it was changed. And I said, if there weren't documents, I just wanted a verbal explanation as to how her job code classification was changed from a senior clerk typist to what amounts to be a museum curator. And I provided you with with my letter in which I went to Human Resources and found out what the job entails, what the qualifications are for a curator. It's a curator 1, step 5 is what she was changed to. And in the process of that change, she was given a substantial pay increase. The job qualifications for I received emails showing that there was a back and forth manipulation of emails so that she could qualify as under museum curator. And I personally don't even think that the job qualification is accurate for what her job entails at the Arts Commission. And the Art Commission responded that they told me when her job classification was changed, but they invoked the laws for an exemption under the Government Code section 624C and 62454K and the San Francisco Administrative Code 67.1, and said that they weren't going to give me any information as to why her job code section was changed. And I pointed out to the Sunshine Ordinance section 6724 subsection C number 6 that basically says public information that must be disclosed, which is under personal information, and number 6 says the amount and the basis and recipient of any performance-based increase in compensation, benefits, or both. And so I'm saying that the Sunshine Ordinance states clearly that if an employee receives a raise in pay or some sort of job raise in pay and benefits, that the basis for which that individual is being given that pay increase and those benefits increase is public information, and the documents or the information should be explained to the public requesting it, because I'm asking them to explain why her job code section was changed to raise her pay, as I said, because if you look at the qualifications for a curator, it has to do with running a museum. It actually has to do with being a curator and doing all sorts of job functions that are related to running a museum and being part of a museum. The job functions which Miss Russell had nothing to do with anything like that. They were strictly clerk, typist, keeping files of applicants and things like that. And to this day, I have not been able to receive any explanation as to why her job code section was changed from senior clerk typist to museum curator number 1. And I think that I'm paying for all their salaries with the street artist fee. And I think that the street artists are entitled to, and this happened, by the way, her job classification, just to close it up, changed on 6/23/05, and I just found out about it recently. We didn't tell anything, and our fees were raised based on what the salaries and benefits of Miss Russell was being paid, and I feel that we should have been informed of her change and why she was changed. Thank you.
Thank you.
I hope that
Thank
makes
you.
it clear.
Is there anybody to present facts and evidence in support of the complainant? Seeing none, is the respondent present? Mr. Rustum?
Mr. Chair, I have a letter from Mr. Lazar saying that he would not be able to attend.
Understand. Is there anybody to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force. Member Snyder.
It seems clear to me that 67, as Mr. Clark points out, 6724C6 requires, among other things, the basis of a performance-based increase in compensation, benefits, or both. And it seems clear, I think we have to assume the facts that are in front of us. Well, we don't have to assume the facts in front of us. We have nothing to contradict the fact that Ms. Russell received a promotion and was presumably upgraded in pay because of that promotion. And that fact, or the basis for that fact, is subject to disclosure under 6724C6. So, pending further discussion, I'd move to find a violation of 6724C6.
Okay, when this isn't yet the time for motions.
Okay, well, in the future.
Yes. Further discussion among the task force. Okay, at this time, Mr. Clark, if you wish, you have 3 minutes to make any concluding remarks.
Yeah, I would just want to say I do have, I don't know whether I put it in the files, but I do have all the records of when her job was changed and everything that was sent to me. So I don't really know whether I should put that in your file, but I can put that in, all that in the file to show that she was changed at that time. I just want to point out that, like I said, that Miss Russell's time, when she was first hired, she was actually hired at a steps 3 of job code 1426, which was a higher level than she needed to be hired at. So even originally she was hired at a level higher. And I just wanted to point out this. It says Miss Russell has 20 years of professional administrative experience and 20 years experience working with difficult people and indigent people in San Francisco. This experience exceeds the requirement for 1426 and is particularly relevant to the Street Arts program, which involves working with indigent, immigrant, and others in San Francisco. So she was hired originally at a higher step level on the basis that she was going to be working with difficult people. And of course, street artists are difficult. We're trying to make a basic living and sell our artwork and our crafts to the public. And this is the person who we go into the office with to renew, ask any questions with. And apparently there was a lot of hostility in the office between Mr. Lazar and Ms. Russell. And there was a lawsuit that was filed between the two of them. I believe it was a sexual harassment case against Mr. Lazar. And it was around the same time as this. So, all I'm saying is that all of a sudden this case gets dropped. If you read the emails from Mr. Lazar to the Human Resources regarding this change, originally the Human Resources said that the original documents that were filed by Ms. Russell didn't qualify her for a curator. Even though a curator isn't necessary, they said, please have her rewrite her qualifications and everything. And they go through a process of back and forth changing it. And finally, Ms. Russell wrote the appropriate change and was approved by Mr. Lazar at that point. And I just want to remind you that I asked Mr. Lazar long ago what Ms. Russell's job code section what her pay was and what her salary was, and he kept telling you he didn't know, he couldn't tell me. And here's evidence that he actually helped her get her job code classification, and all he had to do was tell me to go to the human resources, and I would have found out that information. I believe that he did that deliberately so that I would not become aware that he made this job code change, and hope that nobody would find out about it.
Thank you. Matter is back with the task force. Is there a motion?
Can I ask Mr. Clark a question?
Member Johnson.
Mr. Clark, I'm curious what the, you mentioned in your email to the administrator of your complaint.
Right.
Excuse me. That you received 16 documents comprised 34 pages?
Yes, that's correct.
What were the other documents? You say, I know that you have a description of the ones that are relevant to us, but what kind of information was in the other?
Well, some of it was emails back and forth from Human Resources to Mr. Lazar, trying to help Ms. Russell correctly write up her resume and everything, so she would qualify for it. I mean, I can give you this information.
But they had some relevance, but they were not asked.
Well, everything here just told me what her job code section, new job code section was and when it occurred.
So it was all related to what you had mentioned.
Yeah, but none of it was related to why it happened. It was just when it happened.
Further discussion on this item? Is there a motion? Member Snyder.
Based on my earlier stated reasoning, I'd move to find a violation of 6724C6.
Is there a second?
I'll second. And also, for some reason, I have a lapse in memory of which section for non-attendance.
6721E.
E, right.
Does the maker accept that amendment?
Yes.
Okay, moved and seconded to find violations of 67.24C6 and 67.21E. Member Wolf.
Yes, I would also, I think it might behoove us, considering the repetition that we have to deal with it on this particular agency, that a letter be sent from the task force as a report to the mayor, the board of supervisors, and the arts commissioners over the continued and repeated lack of attendance as required under 6721E to the of this department to participate and attend when requested by a task force, and that some sort of consideration, even financial support, be reconsidered due to this refusal.
Are you making that part of the motion?
I would like to, yes.
Does the second accept?
That was the maker. I'm the second.
Okay. Does the maker accept?
Yes.
Okay. Member Johnson?
May I ask Mr. Clark a question? I may have a friendly amendment, but it depends on his answer.
Mr. Clark, please approach. Thank you.
Mr. Clark, I see that Mr. Lazar told you that it would require a total of $3.40 in order to receive the documents.
That's right.
Did he tell you that you could review them for free?
No.
So I would like to make a friendly amendment that 6728 says no fee shall be charged for making public records available for review. So Mr. Lazar is required to make, Mr. Clark could have come to an office and potentially reviewed those for free.
Well, Mr. Clark, please approach for a second. Did you ask for copies, or did you just ask for review?
I asked for documents, but I keep getting documents that I didn't ask for that are unnecessary.
Well, but did he? The question is, did you ask for copies of documents, or did you merely ask for access to them?
I asked for documents and information. I said if no documents were available, that I would accept an oral explanation.
So you didn't specifically request copies?
I have my letter right here. I mean, I basically, okay, let me see. Sorry. I know I asked for information. I said, sorry, taking a second.
Mr. Rustum?
Mr. Chair, just to let you know that the file does not contain any of the documents Mr. Clark is referring to.
Okay.
I said if there are no documents, then I would like to be informed verbally.
Could you read your request to us?
Sure. It's, I mean, it includes the curator requirement, so it's, you know, it's a page.
Well, could you read what did you say I am requesting?
Yeah. Okay, sorry. It's on 3 pages. I said, basically, I said, after I received the information packet from Mr. Lazar regarding his, Evelyn Russell's, and Leila Conrad's salaries and benefits for the 2009-10 fiscal year, which were provided to Mr. Lazar by the control, I noticed that Ms. Russell's job code was listed as 3541. And then I go through an explanation of what that is and what the requirements are and what the skills are. And then I said, you know, in an email dated 15/2004 from, I'm sorry, Then I basically said she was originally appointed senior clerk type as 1426. So I said I would like a copy of any documents in the possession of the Arts Commission which state when or why Ms. Russell's job code was changed from 1426 to 3541. Now,
That could be interpreted.
I mean, this is what's happening to me. I'm asking a question, and then like any document that has a data in it or something like that, he pulls it aside and then charges me for numerous documents, and before I can't see what's there, and then I go through the documents, and 1 or 2 pages is all that's necessary for me to have.
Thank you.
Rather than making a motion, I would just, Mr. Clark, if I could just point out to you that you are entitled to review them without.
Great.
So just if you don't want to pay, you can request a review where you don't have to pay for the copy. Just
Right.
for your own information, so
Right.
that you're not charged for something that's not answering what you want. So
I appreciate
Thank you. Thank you, Mr. Clark. So 6728 is withdrawn as a friendly amendment. So we now have 6724C6 and 6721E and a letter to the mayor, the Board of Supervisors, and the Art Commission on the repeated non-attendance of complaint respondents. Further discussion. Is there public comment on this item?
Hi, Robert Clark. Yeah, I just wanted to try to get a little flavor for what is happening. Is that Mr. Lazar, we're asking him for this information because, you know, if it had been a normal job, like senior clerk typist 6, then, you know, we could understand it. You know, the woman's been there 5 or 6 years. Right, what was happening is that the level that she went from into a museum curator, that was the highest level that she could be at that time. So if they had given her a job that was senior clerk typist or senior clerk assistant that was a little higher so she could get paid a couple of dollars more an hour, I don't think Bill and I would be even here arguing or asking for this information. But a museum curator? I'm getting old, but I'm not part of a museum yet. The street artist program deals with artists and craftsmen. Has absolutely nothing to do with museum curating. And what we're saying is that there was some kind of a fudge going on in order to get this woman a higher raise for whatever reason. And the fact that she couldn't get one under her normal title, for some reason, museum curator was pulled out, and absolutely under no circumstance does this job relate to museum curating. And you know, the only thing, like I said, you know, we were trying to be reasonable. We've worked with Mr. Lazar for almost 40 years now. And we've tried to have a respectful a relationship with the Art Commission. And, you know, we've found certain things that weren't kosher there, and obviously they're embarrassed about it, and we're having problems with getting any new information from them. But I just wanted to let you know that as myself as a street artist, during this time period that Evelyn Russell got this higher fee raise, the fee became too high for me to pay, and I've had to drop out of the program. I've been out of this program for 2 years now. I started this program 40 years ago with the hope that in my old age that I would have a job and a program that as an artist and as a craftsman, I could fall back on, because I don't get Social Security. I don't want people giving me money. I want to work, and I want to earn my own living. And I worked 40 years ago to ensure that this would be here for me. And because of these shenanigans that are going on over there, the fee has gotten so high, I've had to drop out. And I just want to let you guys know that the effect of a small thing like this on the surface has a major effect on individuals like me.
Thank you. Is there further public comment on this item?
David Pilpel again. The cited section 67.24C6, I may well have been the author of this language. I don't recall exactly, but I wanted to give the task force some history on it. At the time it was written, there was an executive compensation committee that was established pursuant to an MOU with the Municipal Executives Association, and there was a concern that any performance-based bonus that was awarded at that body needed to be disclosed, and under the law at the time, it was not clear that such bonus would be disclosed. I think, again, a careful and narrow read of this language suggests that it's only related to a performance-based increase in compensation, benefits, or both that's awarded to an employee. If a position is reclassified and an employee is subsequently appointed to that different position, which may result in a change in compensation, that's not the same as a performance-based increase in compensation at the same classification level. So it really gets convoluted, and as I understand what Mr. Clark is looking for, I'm not sure that that information about the basis for the promotion or reclassification of Ms. Russell is something that's subject to disclosure. It may or may not be, but I certainly don't think that it's a 67.24C6 issue, and I wanted to make that clear. So I would urge you to reconsider or vote against the motions before you. Thanks.
Thank you. Is there further public comment on this item? Seeing none, public comment is closed. Matters back with the task force. Is there further discussion? Member Johnson.
Mr. Clark, did the documents you contain, I'm sorry, I'm
That's okay.
tired, and you may have already answered this.
Okay.
Did they give you a job description of the museum curator?
Yeah, well, I want to, actually, the documents that the Art Commission provided me did, and I went to Human Resources using the code number, and that gave me the job requirements and what is involved in.
And was among those documents Ms. Russell's resume, or just the trading back and forth?
Yes, it was her final resume.
And so you were asking for the reasoning why she was being moved.
Yeah, I according to him, I was asking him why she was getting a job, an increase in pay and benefits. I mean, I don't know whether it's performance-based or just time-based if I don't know the reason why. I'm assuming nobody gets a job, an increase in pay and classification if they haven't performed to a level of of expertise that entitles them to a pay increase. And so I was just basically trying to find out, why the job classification changed. But if I don't have, I don't know if you have it in the file, but if you go to the Human Resources website and click in on Curator 1 on her job number, it will provide you with all that information.
Okay, thank you.
Thank you.
I hope that answers your question.
Thank you. Further discussion?
Is there any?
Member Johnson?
I'm wondering if someone might address Mr. Pilpel's concerns. Are you concerned as the maker of the motion?
Well, I mean, the way it reads to me is the amount basis and recipient of any performance-based increase in compensation, benefits, or both, or any other bonus awarded to any employee. I mean, it seems much, I understand that the genesis may have been much more specific than that, but that's pretty general wording, and we need to go on, and it falls under a subsection which discusses personnel information. So, it's one of a specific list of specific types of personnel information which has to be disclosed. And the personnel information section, which is C, says none of the following shall be exempt from disclosure, or any other provision of California law where disclosure is not forbidden. And then it gives a list, and among that list is, as I read it, says the amount, basis, and the person who receives any increase in pay or benefits or both, awarded to any employee, period.
Okay. So if, for example, she had just gotten a raise, you would say that, they would say, well, it's just a standards of living raise, a typical, and that would be the reason.
Well, if they came here and testified that it wasn't performance-based, then I would say we might have to reconsider. But the evidence that we have in front of us suggests that it was, she was given a promotion, is what it appears. I don't see evidence that contradicts that this was a promotion.
Thank you.
But
Further discussion? Roll call, please.
On the motion, Member Snyder?
Yes.
Snyder, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 7 ayes. The motion passes.
Thank you. Could you read the next item, please?
Item number 17 is determination of jurisdiction on complaint filed by Susan Dumont against the City Attorney's Office for not responding to an immediate disclosure request.
Is there a motion to find jurisdiction?
Second.
Moved and seconded. Discussion. Is there public comment on the jurisdiction question of this item? Seeing none, public comment is closed. Roll call, please.
On jurisdiction, Member Snyder?
Yes.
Snyder, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 7 ayes. The motion passes.
That takes us to the substance of the complaint.
Mr. Chair, before
Member
you begin,
Wolf?
I just want to reveal that I've had some email interaction with Ms. Dumont, not on any detail in this particular case, and I don't think it would bias or unbias my decisions.
Thank you. Is the complainant present? Is there anybody to present facts and evidence in support of the complainant? Seeing none, is the respondent present? Is there anybody to present facts and evidence in support of the respondent? Without objection, this matter is tabled. Member Wolf?
I just want to say I was a little disturbed by a statement that was presented by the City Attorney's Office through Jack Song, the Public Information Officer, on page 88. He notates, this morning we received an email identifying this as an immediate disclosure request. However, your request is not simple, routine, or otherwise readily answerable and does not meet the criteria for immediate disclosure. I don't know where he comes up with that kind of interpretation, because the Sunshine Ordinance doesn't specify that immediate disclosure must meet this criteria. It only says that they can ask for a 10-day extension if it was not simple, routine, or otherwise.
Okay. If the matter comes back before us, we can address that question.
Very good. I just want to make note for everybody.
Mr. Clerk, could you read the next item, please?
Yes, Mr. Chair. The next item is determination of jurisdiction on complaint filed by Michael Petraeus against the police department for allegedly not allowing public comment during a public forum.
Is there a motion to find jurisdiction?
So moved.
Is there a second? Moved and seconded. Discussion. Is there public comment on the jurisdiction question of this item? Seeing none, public comment is closed. Roll call, please.
On jurisdiction, Member Snyder?
Yes.
Snyder, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Wolf?
Aye.
Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 7 ayes. The motion passes.
Thank you. That takes us to the substance of the motion. Mr. Petrellis, please approach. Thank you for coming, sir. You have 5 minutes.
Hello, my name is Michael Petralis, and I first of all want to apologize for the loud grumbling of my stomach, but this meeting has gone on longer than I thought it would, and I'm very glad, though, that the Sunshine Commission, since the last time I've been here, is really looking at so many agencies and so many issues that have to do with Sunshine, Brown Act, and open government laws. The reason why I'm here is because I was reading some stories in the Bay Area Reporter back in February about the SF Police Department had set up what they're calling the LGBT Forum. It turns out that they are conducting forums with the Latino community, small business community, and this initiative of the forums was started by Chief Gascon. What I read in the Bay Area Reporter concerned me after I think it was the first meeting. They had spoken to a lesbian liaison on the police staff, and she sent an email to the BAR reporter, the bar, saying that the forums are open to the public. However, the nature of the forums, quote, do not provide opportunities for comment by members of the public. Members of the public may observe on a space available basis. I can give you a copy of what that BAR story said in February. Then in March, after they had had another meeting of this LGBT forum, again, at the end of the story, the Bay Area Reporter says that the forums are open to the public, but they don't provide opportunities for public comment. So I filed the complaint with you guys to ask you to look at whether or not Sunshine, Brown Act, all of those things would apply to this forum established by the police, where the police are setting the agenda. The police, as far as I know, are inviting all members of the LGBT forum to be a part of it, and then there's no public comment. I believe that's not the right way to be running this kind of forum, and if you'd like, I can give you the BAR stories.
Thank you. Is there anybody to present facts and evidence in support of the complainant? Seeing none, is the respondent present?
Yes.
Thank you for coming, sir. You have 5 minutes.
Good evening. My name is Lieutenant Simon Silverman from the San Francisco Police Department, and I'm in charge of the...
Speak up in the microphone,
Sure.
please.
My name is Lieutenant Simon Silverman. I'm with the San Francisco Police Department, and I'm the commanding officer of the Legal Division. The LGBT Community Forum is one of a number of advisory committees that was established by the department. In his complaint, Mr. Petralis refers to the LGBT Forum as an advisory panel established earlier this year by the department, which is correct. Under Section 67.3, an advisory committee created by a department head, in this case the Chief of Police, is defined as a passive meeting body. It's not a policy body. Under Section 67.4, gatherings of a passive meeting body need not provide opportunities for comment by members of the public. So it seems that both Mr. Petralis and the department agree that, number one, the department's LGBT excuse me, LGBT forum is an advisory committee, and number two, it does not provide opportunities for public comment. There's no factual dispute before you this evening. Mr. Petrellis' complaint fails as a matter of law. The ordinance clearly establishes that a passive meeting body does not need to provide opportunities for public comment, and therefore, in obedience to the Sunshine Ordinance, the task force must deliver a finding of no violation in this matter. Thank you.
Thank you. Is there anybody to present facts and evidence in support of the respondent? Seeing none, the matters with the task force. Any questions? Member Snyder.
Mr. Silverman, can I ask you a question?
Yes, sir.
The members of the LGBT community forum, who are they? Where are the members selected from?
You know, I'm not exactly sure. I know that it's a community outreach project, so it may be people that were contacted by the department. It may be people that approached the department. It may be a mixture of both.
Is it city employees?
Other than the members that are SFPD employees, no.
So are there a number of members who are necessarily police department employees?
Some of the members in each of the forum, or participants in each of the forum, would be department members because the purpose is community outreach.
And the rest would be community members?
Yes, sir.
Okay, that's all. Thank you.
Member Wolf.
Yes, what's your rank, please?
I'm a lieutenant.
Lieutenant Silverman, correct?
Yes, sir.
Okay. Is this considered an advisory board? Or
Yes, sir.
It's considered, okay. And the advisory board was created by who?
The department head, the chief of police, or designee.
Okay. Okay. Again, and I don't know if I heard the correct answer or not. In the membership of the advisory board, who are they?
Community members. And then it's essentially a discussion forum between the department and members of the community.
So are there any members of the police department on this board? Do you know?
Well, participating, yes. I mean, the forum would consist of members of the community dialoguing with the department.
Well, so maybe I'm a little confused now. So is this a board made up of members where there is like a quorum for them to be able to hold a meeting, or is this just a public speaking engagement?
It's just a forum, a dialogue. No policy is set. No particular.
Is anybody appointed to this?
I'm not sure.
Or is it just people, it's a time and place, somebody shows up, somebody facilitates, and there's discussion?
Yeah, it's certainly open.
That's not my question. My question is there a formal structure to these, and is there like a panel or a board that commences these forums or these meetings?
I'm not certain of the exact format.
Okay, so you're not familiar enough with the actual body itself to answer these questions?
No, I haven't attended these meetings, so I couldn't say for certain.
You weren't informed about the makeup or the structure of these meetings?
Correct.
Okay, thank you very much.
Okay, at this time, the respondent, Lieutenant Silverman, at this time, the respondent, and then the complainant will each have 3 minutes to make any concluding or rebutting remarks.
Submitted, sir.
Thank you. Ms. Petrellis.
Thank you for this extra opportunity, but I've said what I wanted to say. Thank you.
Thank you. Matters back with the task force. Is there a motion? Member Snyder.
I don't have a motion, but I would just, to me, it sounds like this is a classic passive meeting body. I haven't heard anything that suggests otherwise. And because it's a passive meeting body, they are required to allow members of the public to attend, but the ordinance makes clear that they are not required to provide opportunities for the public to speak. And we can disagree with that as a policy matter. I don't think it's a good idea personally, but the ordinance says what the ordinance says, and I've heard nothing that suggests that this isn't a passive meeting body, and so those are the requirements for a passive meeting body.
Member Wolf.
So I have a little different take on this. I mean, I don't know who the members are. I don't know. They could be all employees. But the person who was sent here to answer those questions doesn't have the answers. He was not either not.
That was
not. Sorry, go ahead. Hold on. He was either not informed, or he's not knowledgeable enough to answer the question. So, you know, I find it a little hard to just accept that it's a passive meeting body without having that information. If it's all employees, well, that takes into a different area. If they make certain decisions regarding certain things, I don't know. If it's a forum that has no, structure or body, it's just show up at this place and we'll all have some tea and a discussion. That's something else then. So that's it.
Member Snyder?
I mean, I think Lieutenant Silverman, that was the question that I was asking, was getting at the composition of the body. And I think you revealed that he doesn't know the details of the composition, but I think he testified, Lieutenant Silverman testified, that it's not entirely made up of city employees. And it's not a passive meeting body if it's solely composed or comprised of city employees. And he said it's not. And what we know from the Bay Area Reporter article that we have is that, or the quotes we have from it, suggests that that's not the case either. It doesn't sound like it's the sort of thing where it would just be city employees. It's a community outreach, so they're going to have members of the community.
Member Wolf.
Let's break down the definition with regards to passive meeting body. If they were all employees, then it wouldn't be under sunshine anyway, because it would be considered more or less a staff meeting. Okay. The other aspect is if you go up to 67, what is this? 67. Come on. 67.3 D C. Okay. No, I take that back then. No, I don't. If you go down to D3, it says D4. It says any advisory board, commission, committee, or body created by the initiative of a policy body is a policy body. Okay. Under D it says a policy body shall mean, and then under number 4, any advisory board, commission, committee, or body created by the initiative of a policy body. I can't get at whether this was created by the commission or by the department. Now, it was testified that it was by the department. Okay, so then it would take it into a passive role. But the question is the police department a policy body? And would the police department be considered a policy body, or is the police commission considered a policy body? And that's where the sticky wicket is for me.
Member Johnson?
He didn't testify that he knew that I think he said he knew that part of the committee was not police employees.
Doesn't matter. If it just says any advisory board created by the initiative of a policy body, doesn't speak to its membership.
But could you
Lieutenant Silverman, could you please address the question?
Yes, sir. These were the forums were established on the initiative of then Chief Gascon, and in fact, in Mr. Petrellis's statement, he actually said that as well. So the forum's not established by, it's established by the department head. The department, as I understand it, is not a policy body. The policy body relevant here would be the police commission, and the police commission didn't establish the forum.
Okay.
It was a chief's initiative.
Thank you.
And I would just ask Mr. Petrellis if he understands that to be true.
Yes.
Okay.
Thank you.
Then I'll retract my supposition.
Is there a motion? Is there public comment on this item?
Thomas Piccarello, I'll be brief. It's late. I don't believe the respondent had enough information in order for you to make the determination if this was a passive body or a public policy body. I mean, I would like to hear some questions. Are these advisory groups, these forums, are they funded at all in any way by the city? And where are the venues? Are the venues on city property? So there's a lot of factors that I think that you need to find out, determine before you reach the conclusion that these forums that Mr. Petrellis wanted to comment on are a passive body. So I would think that perhaps you may want to continue the matter so there'd be the next respondent would be able to answer more of your questions. Thank you.
Thank you. Is there further public comment on this item?
Yeah. I just think it's bad faith that, you know, we let the city to set up meetings and then turn their back on the public while they watch, while they do whatever. But I think we need more information before we really make a decision. The other thing too is they're saying that the room that they have the meeting in might be too small for public comment. So I'm just wondering, are they even following the laws regarding AMADA? I mean, there's no agenda. So it just seems like there's a lot of problems and not enough information. I just hopefully that you'll amend this section of the code so that, you know, they don't have to continue to just ignore the citizens of the city and county of San Francisco.
Thank you. Is there further public comment on this item? Seeing none, public comment is closed. Further discussion by the task force. Member Johnson.
I do agree with Member Snyder that it sounds like a classic passive meeting body, and there's two representatives from the police department here because we have a letter too saying that it was created by the Community Relations Unit, and since Mr. Petrellis also has the understanding that it's an advisory body, but I think that it fits passive meeting. But I did want to point out that, you know, there are both if you don't think that it's appropriate, or if you feel that the public comment is missing, you know, you can address not only the police department's community relations unit, but there is public comment required at the police commission, and there's general public comment before the board of supervisors, so you can try to bring it up that way, as well as contacting the people who are operating it with maybe some specific examples of why public comment should be at this particular forum.
Further discussion. Okay. This matter is concluded. There is no motion. This matter is concluded. Thank both sides for attending. Before we get on to announcements, I want to revisit the question of attendance at this meeting and absence from this meeting by members of the task force. There are 7 of us here. There were 1 member, there were 8 of us total tonight. Member Cawthon left early, stating she had wanted to attend a dinner of San Francisco tomorrow, which she is a board member. Is there a motion to declare Member Cawthon's absence excused?
I would so move.
Is there a second?
Second.
Moved and seconded. Discussion. Member Wolf.
I object to that. I'm a member of San Francisco Tomorrow. I knew about it over a month ago when they sent out their newsletter. I paid for a seat, before this meeting was called, thinking I was going to be able to attend. But when the meeting was called, I called them up to remind them today that I wouldn't be able to make it, and they could give my seat to somebody who might be in need of it. I felt that my duties here were more important than a social occasion that happens annually, year in, year out. And I just don't feel it was appropriate for her to leave in the manner and when she did. I just don't feel it was appropriate.
Okay. Further discussion, Member Johnson.
Because we sometimes have problems getting quorum and getting them on time, I tend to agree with Member Wolf because there are many times that, as you know, as some of you know, I follow many things. I'm not necessarily on the board, but I miss a lot of things that I did related to politics. Because you have to make decisions about your responsibilities. So it wouldn't be a problem if we didn't have a problem getting quorum on time, but it seems to me that an excused absence would be something more along the lines of not an active choice to pick one of your other political items, especially in this particular instance. Member Cawthon does library work. She does, I know we all have other outside obligations, but making a choice like that, if Member Wolf had made the same choice, we would have not had a quorum, and we would have left at 5:30. So it makes it hard for me to, I don't mind that she was gone as much as Member Wolf because I'm not in the middle of it, but to make it an excused absence seems unfair to those who make a decision to put this as a priority.
Member Wolf?
I would just say, just on my own behalf, for every meeting that we have, I have to forego a major responsibility, a meeting with people, an open public assembly, and then it's a board meeting for an organization I belong to. And they know this because I serve on this body, but because it meets on Tuesdays and they meet at the same Tuesdays every month that we do, it's disturbing for me that I can't be there with them for the important work that they do. But I realize that this is important too, and I think after we had 2 recusals on the same item that we had, because she was gone, that we had to then continue the item. I think that that's not right. I'm concerned about it. And never mind the other members that are not here today, also, and we are.
Does the special meeting count against the?
No, only regular meetings count on that. I have an objection to the motion also, and that is when I first announced that we needed a special meeting, the first date I proposed was May 19th. That would have been tomorrow night. And immediately Member Cawthon said she had something else, and she asked me if I couldn't make it to do it on another night. And when I announced for tonight, she gave me no indication she could not attend. She sprang this on us tonight, and furthermore, San Francisco Tomorrow, it's an organization I like, that I admire. They do a lot of good things, but it is not an official body of the city and county of San Francisco. The task force is. And so I'm going to vote against the motion to excuse Member Cawthon's absence. Is there further discussion? Is there public comment on the motion?
Yeah, I would agree. San Francisco Tomorrow does a lot of good stuff, but in my opinion, this task force is much more important to a lot more people. Again, I want to thank you, the 7 of you, for being here tonight and imposing on your other stuff. You got a backlog of cases, and but that's probably a good thing. That means that more and more people are wanting to be involved in the public process and getting records and commenting. So that's a good thing that you're backlogged. But regarding Ms. Cawthon, I don't believe this should be an excused absence. Thank you.
Further public comment? Seeing none, public comment is closed. Further discussion? Roll call, please.
On the motion, Member Snyder?
Yes.
Snyder, Member Manny?
Pass.
Member Washburn?
No.
No. Member Costa?
No.
Costa, no. Member Wolf?
No.
Wolf, no. Member Johnson?
No.
Johnson, no. Member Wolf, I'm sorry, Member,
Manning?
Member Monak?
yes, Member Manning, thank you.
No.
Manning, no. Member Nee?
No.
Mr. Chair, there are 5 noes, 5 for and 1 against.
I'm sorry?
It can't be.
No.
There's 7 of us.
Six.
We've done the math. It has to add up to 7.
6 Wolf noes.
6, yeah,
6, I believe there was one aye, 6 noes.
1 against, yes.
Okay, Member Kneber, I believe his absence is work-related. Without objection, excused. Member Costa, his tardiness was work-related. Without objection, excused. Member Chan, I believe his absence is work-related. Without objection.
School,
I'm sorry?
or school. I
Or
remember
school,
you said.
that's right, I believe he's in school. Without objection, excused. Member West, I received an email from him today. His absence is work-related. Without objection, excused. Mr. Clerk, could you call the next item, please?
The next item is announcements, comments, questions, and future agenda items from task force members.
Any announcements, questions? Member Wolf, and I will have one also.
Yeah, I would think it would behoove us to put on our website a section called making, or tips on making a sunshine request with regards to some of the issues that came up for the supervisors, where they claim their interns mishandled or missed or whatever. I think it might be good to put somewhere on a website, and we can have it ongoing, but one maybe should be right on the front of the envelope that this is a sunshine request. When you do an IDR, you have to do that anyway. But I think for all sunshine requests, it should be that way, because they receive sometimes personal stuff. Who knows what they receive. And I think it would be good just to notate it, so they know to put it on the side. Also, I think it'd be a good idea. We've heard a lot of testimony for the issues that are related to the original request made by the complainant. But we don't have the original request. All we have is what they put in the complaint. And so it's hard for us to see or know what the original request is, and sometimes you're just standing there reading it off. I think it would help us a lot if, when they make the complaint, that they supply the task force with their original request prior to the agenda being finalized, or it would be continued. If they made an oral request? Well, if they made an oral request, then that's something different. But if it was a written request, we've heard several times tonight, we didn't get, and frankly, I'm a little astounded by our agenda and how it's constructed, not by our administrator, by the lack of memorandums from the city attorney. There's only one memorandum for the entire agenda for tonight. Also, we might want to think about utilizing 6721D a little bit more on items where documents need to be determined whether they're public or not. Like in the case of Mr. Littlejohn, he actually did go through the proper procedure. He went to the supervisor of records first, and the supervisor of records did as the Sunshine Ordinance told that person to do. Made a determination and then ordered the body to produce the documents. And if that didn't happen, then he can come here. But that's another avenue for that I think should be exercised if possible, and that may very well be a good place to happen at the phone call to the office level if somebody wants to file a complaint, to ask, is this in relation to determining whether something is public or not? And if the answer is yes, then a suggestion is to start at the supervisor of records, because if they can solve it or get it done I'm sure if somebody received an order of determination from the supervisor of records from the city attorney's office, that would kind of carry some weight more than what we've experienced. So that might be something that we can build in. I think I'll leave my last item. I'm going to suggest that at our next, I don't know if it could be at our next meeting, but probably in the June meeting, that we have a discussion about changing out our attorney representation.
Okay.
Because of certain instances that have happened, including today, just what's happened functionally for us today.
Member Johnson?
I wanted to make a request that we put on the agenda an item having ESC added to members who are in seat 1, because seat 1 requires that you are an attorney, and there are other commissions that just put it up there anyway, but ours is an actual requirement, and it would document that. And it could be on the agenda, for example. It would carry over, not just from Member Snyder, but it would say, you know, seat 1, it says David Snyder, comma, ESC.
Mr. Rustin, please note.
No, we'll do that.
Thank you. Member Snyder?
On the memo issue, there were more than just one DCA. Yeah, thanks. Very nice. He added it to me. Yeah, thanks. There were more than one memo. The problem is some of these were carried over from before, and so Jerry did memos for a number of these, but they weren't in our packet today for whatever reason. So I had to go back to the last time and dig through, because I wasn't able to make it to the last meeting unexpectedly, and I'd read through all this stuff, and I thought, well, where were the memos on these? So there were more than...
They got emailed to us after
the
agenda.
Right.
You mean the last time around?
Yeah, last time.
Oh, that's why they weren't. Oh, okay.
Yeah.
All right. Well, yeah. I mean, just sort of so I think Jerry's memos I think he does a great job on the memos that he does. They're good, and
I'm not disputing that.
yeah, the ones that we had, the Ethics Commission, Mr. Manette Shaw's complaints were really loaded with a lot of issues, really interesting and complicated issues. And Jerry's memo, I thought, did a really good job of parsing all of that. And anyway, just in his defense.
Through the chair, my concern is more. I mean, even for this, it was like I didn't think of like, okay, these were carryovers. I didn't, I sort of maybe my own fault. I didn't remind myself of that. But at the same time, I couldn't. When I looked through my last, I didn't see them there either. So, I would just say I don't know what to do about that then.
Well, it's a good idea if something is continued from one meeting to the next, it's a good idea to have all the supplementary information included with the information packet in that latter meeting. Mr. Rustum?
Mr. Chair, I think the only DCA letter I missed was for items number 1 and 2.
Okay. I have one item I'd like to bring up, and I've already emailed all of you about it. But for members of the audience, there is a proposed Senate constitutional amendment proposed for placement on the ballot this November. It's Senate Constitution, or maybe possibly next June, but it's Senate Constitutional Amendment 7, authored by State Senator Leland Yee. State Constitutional Amendment 7, authorized by State Senator Leland Yee. What it would do is strengthen and tighten agenda posting requirements for cities, counties, school districts, etc. The amendment has been placed in the suspension file of the Senate Appropriations Committee. This is a major block on it. This is a major obstacle. This was done, as I understand it, this was done in secret between that committee's chairwoman, Christine Kehoe, Kehoe, and Darrell Steinberg, who is this Senate President pro tem. So what I am asking us to do, and we can't, obviously we can't do this as a body, but I would like to encourage each and every one of us to contact Senator Steinberg and Senator Kehoe, and maybe copy any communications to Senator Yee, and let them know that it is unacceptable to keep Senate Constitutional Amendment 7 off the ballot. And remind them when you communicate with them, tell them, I vote. Always say, I vote. That makes them, that does draw their attention. Their contact information, I have included that in the emails that I sent to you. For those in the audience, you can find it at www.senate.ca.gov, and you can find it on that site. That's what I have.
I'm just wondering why we couldn't write a letter as the body.
Because we haven't voted on it, because we haven't put it on the agenda.
Oh, okay.
Right.
I thought you meant that we couldn't do it because it's something we're not
No,
allowed
but
to
I would
do.
encourage, and for those of us on the task force, I think if we identify ourselves as members of the Sunshine Ordinance Task Force and explain what that task force does, I think it gives what we say, what each of us says, some additional clout. Okay. Anybody else? Member Costa.
Just have a quick question. Are we going forward with the amendments package? But I saw that those deadlines.
Oh, we are trying. Yeah, we are trying. I have sent an initial approach, feeler to Supervisor Avalos. I have not heard back. I have to finish kind of wrapping up a summary of what we're putting forward. There are some areas that, most of it I've got down, but there were some areas at the last special meeting that we put in there, particularly definitions, and so I have to nail those down, make sure the package is what we say it is, and then take it to, we hope we can find 4 supervisors to put it on the ballot for this November. I think we're within the time frame, but it's getting real close. You know, they're going to want time to digest it, and you know, we'll need time to talk over with them what we think can pass and what we can't. We have to figure out where we're going to be willing to make compromises and where not. Anything else for the good of the order? Motion to adjourn?
So moved. Oh, no public comment.
Thank you.
I don't know.